admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-3044, United States of America versus Dwight Hayman, also known as Pee Wee, also known as Wee, appellant. Ms. Yang for the appellant, Mr. Goodham for the appellee.
Good morning, and may it please the court. Mr. Hayman was entitled to an appeal, but his trial counsel failed to provide adequate consultation about an appeal in two independent ways. First, he failed to advise Mr. Hayman of the advantages and disadvantages of an appeal. He gave inaccurate advice. He mistakenly claimed the government would treat an appeal as a breach of the plea agreement, but he expressly permitted the ineffective assistance of counsel claim that trial counsel and Mr. Hayman had discussed. He then steered Mr. Hayman to raise his ineffective assistance claim through a collateral 2255 motion, but he failed to explain that by pursuing this lesser remedy, he would lose the right to counsel that he was guaranteed only on direct appeal. Separately, his counsel also neglected to make a reasonable effort to discern Mr. Hayman's wishes regarding appeal. His ministerial instructions about the 14-day deadline were insufficient to satisfy his duty to consult. Either error.
What would he have argued on appeal?
On appeal, the claim that was preserved was ineffective assistance of counsel. And this
How is counsel ineffective? Because if he had taken the direct appeal, he couldn't base the ineffective assistance claim on the failure to take a direct appeal.
That's correct, Your Honor. This court has recognized that the Strickland analysis is a fact-intensive one, and that the facts needed to establish ineffective assistance of counsel is not typically part of the district court record. And so upon filing a notice of appeal, Mr. Hayman would be appointed a new attorney who could then help him reassess trial counsel's performance.
Argue that the plea deal that the district court thought was so extremely favorable to Mr. Hayman was in fact ineffective assistance.
Well, what we don't know based on this record is the scope of the investigations that trial counsel did to test the sufficiency of the government's evidence and to test whether there were any defenses that could be raised for Mr. Hayman. And those are precisely the questions that could have been answered on direct appeal had Mr. Hayman had the opportunity to have appointed counsel help him reassess trial counsel's performance. And in recognition of the fact-intensive nature of the Strickland analysis, as well as the fact that the facts needed to establish ineffective assistance of counsel are not typically part of the district court record, it is this court's general practice to remand an ineffective assistance claim that's raised for the first time on direct appeal back to the district court, so long as the record does not conclusively show that the defendant is not entitled to relief. And that is precisely the circumstance here, where the record is insufficient to demonstrate one way or the other. And so Mr. Hayman should not be punished for having lost the opportunity to raise that claim on direct appeal due to the deficient consultation provided by trial counsel. At a bare minimum, the decision whether to appeal was one that belonged solely to Mr. Hayman, and he was deserving of receiving accurate advice. The inaccurate advice that trial counsel gave about a purported disadvantage of appeal, as well as the steering that occurred that made Mr. Hayman believe that the only viable avenue for him to raise ineffective assistance was through a lesser collateral remedy. When paired together, that constituted deficient consultation due to trial counsel's failure to advise Mr. Hayman adequately of the advantages and disadvantages of an appeal. And separately, his counsel also neglected to make a reasonable effort to discern Mr. Hayman's wishes regarding appeal, and those ministerial instructions about the 14-day deadline were insufficient to satisfy his obligation to consult. Either of those errors constitutes deficient consultation that satisfies the first step of the Strickland analysis. As for the prejudice prong, the district court did not make any factual findings or rulings regarding prejudice, and so remand would be proper in this instance so that the district court could reach those findings in the first instance.
Can you help me with a theoretical question about how the prejudice prong works in this context? It seems like maybe it not only overlaps with the two ways that you could show that there was a duty to consult, but it may be entirely duplicative of that. So the two ways to show a duty to consult: number one, a rational defendant would have wanted to appeal. Number two, your particular defendant demonstrated that he wanted to appeal, even if he didn't expressly say so. If you can't prove either of those, I'm not sure how you could prove prejudice.
Those two avenues are not duplicative of the prejudice prong, and the reason why is for two reasons. As for the test regarding whether a rational defendant would apply, the Supreme Court has explained that even in the absence of non-frivolous grounds for appeal, so long as there is substantial evidence of a reasonable probability that this particular defendant would have appealed.
That's the second way to show there's a duty to consult.
Yes, Your Honor. And as for the second, the duty prong looks solely at expressions of interest that this particular defendant made to trial counsel. But the prejudice prong could look at any types of actions or expressions made by Mr. Hayman, and not limiting that analysis strictly to the expressions made directly to trial counsel.
In this case, that doesn't help you, because the kind of one piece of evidence we have about things he said to people other than his trial counsel, I think he told, actually it was to his trial counsel, he said, "Tell my Maryland lawyer that this case is over." What could he have meant when he said this case is over, other than I'm not going to appeal this case?
Trial counsel explained during the evidentiary hearing that the purpose of that statement was to inform the Maryland attorney to continue. The Maryland attorney's purpose was to determine into whose custody Mr. Hayman would go once the sentencing concluded, whether he would go to federal custody or whether he would go to Prince George's County due to a pending Maryland case. And so it was for that strategic reason that he was instructed to inform the Maryland attorney that the proceedings had ended. It was not an expression of an interest in concluding the proceedings, but rather a statement informing the Maryland attorney that that decision would now have to be made.
What's your best piece of evidence that this particular defendant wanted to appeal? Is it that he was dissatisfied with the 15-year plea deal?
What we have here on this record is much more than general dissatisfaction with the plea. Mr. Hayman had many consistent conversations with trial counsel over the proceeding. They discussed his desire for trial counsel to do something more to omit the 924C gun charge. They discussed withdrawing the plea. They discussed raising ineffective assistance.
That's not, I appreciate that and thought it was well briefed. If you had to just point to one thing, I'm not saying that one thing has to be dispositive. Obviously, we look at your strongest piece of evidence and your second strongest and your third, and we put them together and we consider them as a whole. But what is your strongest piece of evidence that he wanted to appeal?
In addition to those statements, I think the strongest piece of evidence is the fact that he listened to trial counsel's advice and timely filed his ineffective assistance claim through his 2255 motion. What that reflects both is that he was willing to raise ineffective assistance of counsel, and that had he been provided adequate consultation, he would have raised that on appeal.
Can we consider that 2255 motion in making this analysis, or do we look at the time that counsel was making the decision whether the client wanted to appeal? We look at the universe of facts then. Is there any case or authority to look at something that postdates by 50 weeks, or almost 50 weeks, that critical decision to appeal or not in deciding whether he wanted to appeal?
The duty analysis is restricted to what counsel knew at the time that the consultation was provided, but it would be relevant in determining the prejudice prong. And as for that duty to consult, another strong piece in the record is trial counsel's own testimony that raising ineffective assistance of counsel through a collateral remedy is not typically part of the advice or consultation that he gives to all of his clients, but that he did so here because of the particular conversations that he had had with Mr. Hayman. What trial counsel's mistake
was. So there the evidence is what counsel was discussing with Mr. Hayman at the relevant time, not the fact that he actually filed one later. but your focus seems to be on the discussions Mr. Hayman was having with Mr. Katsas, contemporary with the representation, indicating that he thought Mr. Hayman wanted some form of future proceedings, whether it would be 2255.
Right, Your Honor. Those conversations that were happening before the appeal deadline expired reasonably demonstrated to trial counsel an interest in challenging his conviction and sentence. And trial counsel recognized that by raising for Mr. Hayman the avenue of ineffective assistance through that collateral remedy, which he testified was not part of his typical practice. And the duty to consult, the Supreme Court has explained, is expected to exist in the vast majority of cases. And lay defendants are not expected to invoke any precise legal words or legal terms to trigger that duty. And so other courts have held a duty to exist where a defendant raises a simple question such as what's next after sentencing, or makes a single statement expressing a desire to do something to reduce his sentence. And what we have here in this record are consistent and ongoing expressions of interest by Mr. Hayman to trial counsel that reflected that interest.
Can you clarify one thing factually for me? After sentencing, he met with the government. Was that meeting set up before sentencing or after sentencing? Was that all a post-sentencing process, or do we know the timeline of that?
I'm not entirely sure, Your Honor. I believe that meeting was set up before sentencing to occur post-sentencing, but the content of those conversations demonstrated that Mr. Hayman continued to express a desire to trial counsel to do something more to challenge his conviction and sentence. And during those three encounters, the purpose of it was very much reflective of the consistent and ongoing interest that Mr. Hayman had been expressing to trial counsel before sentencing that continued even after sentencing.
Certificate of appeal did not specifically mention the prejudice prong of Strickland. We could still, I think that alone does not preclude us from considering the prejudice prong. Do you agree with me on that?
I'm not entirely sure, Your Honor. I know that this court can address questions of law that the district court has not addressed, but that the general practice is to allow the district court to do so in the first instance. And I think that's particularly true here, given that the prejudice prong is a mixed question of fact and law, and any factual findings would be reviewed on clear error. And because the district court did not make any factual findings regarding prejudice, and because the factual findings for prejudice are not coextensive with the findings needed for performance, it would be proper to allow the district court to reach those findings and to reach that ruling in the first instance.
I thought Judge Walker was asking whether there's any legal barrier. The fact that the certificate of appealability referenced two particular issues. As a matter of law, that doesn't preclude consideration of the prejudice question. You've raised common considerations that we would keep in mind on issues in any appeal, certificate of appealability or not. But the law, I thought, was pretty clear that we are not confined to just the two questions that were mentioned, because what was certified to us was that he had made a showing of the deprivation of a constitutional right, and so that constitutional question is what's certified.
I believe that's right, Your Honor.
And it's not jurisdictional anyhow.
I do not believe it is jurisdictional. And here, if this court does choose to look at the prejudice prong, there is substantial evidence in the record of a reasonable probability that Mr. Hayman would have appealed but for the deficient consultation. In addition to the timely filing of ineffective assistance of counsel, which reflected that he followed trial counsel's advice and would have raised that if he had known it would not reach the plea agreement and that he had a right to counsel on direct appeal, the record also demonstrates diligence on Mr. Hayman's part in pursuing that remedy. He repeatedly attempted to access the law library where he was confined, and after he was restricted access on multiple occasions, he affirmatively reached out to the Federal Public Defender's Office for their assistance in preparing that filing. And so it is the diligence through which he pursued that remedy, in addition to the timely filing of that ineffective assistance claim, together that collectively demonstrates prejudice here. All right, no further questions. I reserve my time for rebuttal.
Thank you, Ms. Yang.
Or David Goodham for the United States. If I could, I'd like to address the factual question you asked, Judge Millett, relating to whether the meeting was scheduled before sentencing. I think that is answered at JA 300. Mr. Katsas is describing that the government was willing to have a meeting, and Mr. Katsas said he would, quote, schedule it closer to sentencing, and that was a description of a conversation he had with the defendant between the plea hearing and before sentencing.
Thank you.
With respect to the two pieces of the puzzle here, if with the court's permission, I'd actually like to start with prejudice, if I might, as Strickland counsels, if this court can easily or more easily resolve an ineffective assistance to counsel claim via prejudice, it is, of course, free to do so. My opponent has suggested.
Is there any certificate of appealability barrier to us doing that?
I don't think so. As was previously alluded to, I understand that this court is always concerned about the issue of whether or not it was presented to the district court, and I believe that's this court's decision in Lockett. But in this case, prejudice was presented to the district court. It is 100% true that he did not rule on it. He decided there was no deficiency. But if you look at the pleadings, the post-hearing pleadings in particular that we cited in our brief, the Mr. Hayman first raised the issue of a non-frivolous issue on appeal and related it to prejudice. Then the government answered and said, well, no, he hasn't shown prejudice. So true, district court did not rule on it, but I think that covers the certificate of appealability problem, number one. Number two, and I think this gets to the issue of my opponent's suggestion there were no findings of fact that are available to support a prejudice finding if this court wants to embark on that. And what Flores-Ortega says is that, and I'm looking at 528 U.S. at 486, there is overlap between in the unique circumstance of a missing notice of appeal, there is overlap between the prejudice inquiry and the deficiency inquiry. And in particular, there are two factors that the court looks to when assessing each. One, identification of non-frivolous issues for appeal, number one, and number two, any indication in the record that the defendant himself wanted to appeal. And in that context, this district court did make the relevant findings that I think would support, if this court wanted to go down that road, the prejudice conclusion. And I would direct the court to—
So the deficient performance inquiry turns on this duty to consult, which in this case, I don't think there were any non-frivolous grounds. So this turns on whether there was an indication that this defendant wanted to appeal.
Yes, that's—
And the prejudice inquiry, I'm not sure I'll get the precise adjective or adverb, but under Strickland, it's whether there was a reasonable possibility that, in this case, the defendant would have taken the appeal, right? So those seem almost, if not identical, at least parallel. So why would we not just rest on the ground asserted by the district court?
Certainly, that's available. We briefed that fully. We think that supports, the record supports the district court's conclusion. I think—
Prejudice easier for you? I'm just curious why you're going first to prejudice.
Well, my opponent has suggested the consultation was inadequate, for example, number one. So that gets to the adequacy of the consultation.
Presupposing a duty to consult, though.
Right. And I was just going to turn to that. What this court has counseled and what Flores-Ortega counsels is that it is a very rare situation when you don't have a duty to consult. We think in this circumstance, very unique circumstances, we meet that test. There was no duty to consult here for all the reasons we've outlined in our brief. But we recognize that this court's decision indicated that should be a very rare scenario. So our take on this is that you don't even have to satisfy that. You don't even have to be comfortable with the notion that this was one of those very rare circumstances. Instead, you can look at this.
But how does that make the case easier for you on prejudice? If you have a high burden to show no duty to consult, and let's assume for the sake of argument, the consultation was inadequate.
Sure.
Wouldn't you have a comparably high burden to show prejudice?
No.
Why?
What Strickland teaches is that it's the defendant's burden to show a reasonable probability that this would have affected the outcome. And what Flores-Ortega says in particular is a reasonable probability that but for the missing consultation,
Right.
the inadequate consultation, he would have appealed. And so I guess my point is that
The burden shifting, that makes the prejudice prong easier.
I think
The
so.
burden shifting.
I think so. Well,
Right.
we have the Strickland overlay of burden on the prejudice. Then we have the additional, what Flores-Ortega said was a critical factor, a critical showing that there was a but-for circumstance here. And so that my only
So
point.
parallel inquiries, but shifted burden on prejudice?
Yeah. And so my only point is that Mr. Hayman got appointed counsel below. He has appointed counsel on appeal. I've yet to see an identification of a non-frivolous issue for appeal. The counsel below tried to make some arguments, and if you look at JA 379-80, the district court dismissed them out of hand, I would suggest. Although he recognized, although the defendant is not required to identify a meritorious ground for appeal, he said the defendant has, quote, struggled to articulate a viable argument. And I think that's a charitable statement in terms of the identification of a non-frivolous issue. So we have that finding, in fact, I would suggest, number one. Number two, what Flores-Ortega says is this court should consider whether the defendant has, quote, promptly expressed a desire for appeal. And again, if you look at the court's findings of fact at JA 381, the court says, I find that Hayman did not at any time indicate during the period, that is the 14-day period, that he was interested in appealing. You couple that with the silence, that undisputed silence that unfolded thereafter all the way till 23 days before the expiration of the year period for a 2255. And I would suggest you have a significant factual foundation.
Well, there was certainly evidence that he was, he wanted, there is evidence pointing both directions here. There's evidence that he wanted to do something to get this, at least the mandatory minimum, the 924C, knocked down, that part of it at least. And he met with the government after sentencing, and that did not go as he had hoped. And Mr. Katsas keeps saying, I don't normally tell him about 2255, but I did in this case because I knew he was unhappy. And so I think we have to reckon with the fact that there are indications here that Mr. Hayman was unhappy, wanted to do something about this extra time, at least that much from the mandatory minimum, 924C, and that Mr. Katsas knew, because there would have been no reason for him to keep talking to him about 2255, but not appeal. There was no reason to talk about one, not the other, if you thought that Mr. Hayman had no interest in going further, right?
I disagree, Your Honor, to the extent that, and I know that my opponent has suggested that the only reason 2255 was on the table and as a discussion matter was because of this dissatisfaction. I don't think that's an accurate reading of the record. This court, of course,
Why was he talking? Tell me why you think he was talking about 2255 if he thought Mr. Hayman wasn't interested in any further judicial review.
It was part of the plea agreement, Your Honor, and in particular, as I read the record, that 2255 came up two times. Number one, it came up as they were discussing the plea agreement, sorry, Your Honor, I'm trying to find here we go. And then it came up again as Mr. Hayman was contemplating withdrawing his plea. And at that point, we're at JA 326, 327. It is true, Mr. Katsas reminded Mr. Hayman of the things that he had not forfeited by his appeal waivers. And he says at 327, At this time, we talked about both 2255 and direct appeal separately. I wanted to remind him that he had that avenue if he wanted.
But he also had, the appeal waiver did not cover raising ineffective assistance of counsel on direct appeal either.
Sure.
But he wasn't telling him about that.
Well, again, I think the record demonstrates that every time he talked about these two things, he talked about them together.
Well, no, there's the worst, because in fact, he told him that he was concerned that if you do the appeal, that the government will treat that as a breach of the plea agreement. Now, I assume on behalf of the government that you would agree that that was an erroneous reading of the plea agreement to think that he couldn't have done a direct appeal on ineffective assistance of counsel.
100% agree. And
so that was a completely wrong, erroneous advice that he gave him. To the extent he said that if you're appealing ineffective assistance of counsel, I mean, he was indicating that an appeal could cause the government to withdraw its plea agreement, knowing that there'd been one risk of that already. Maybe that would really scare Mr. Hayman. But in fact, there was zero risk had he appealed on ineffective assistance of counsel.
Sure. And again, I can stand here as a member of, as a part of the government and say, of course, we would not have suggested that a notice of appeal equaled a breach. But what I will say is this: in the context of the circumstances of this case, I would suggest that was not an unreasonable warning on the part of Mr. Katsas. And that's for two reasons. Number one, Mr. Katsas had just gone through a very, what I would suggest, recent effort to talk to Mr. Hayman about his desire to withdraw his appeal because he thought the substantive validity of the 924C was not supported by the evidence. Mr. Hayman decided not to withdraw his appeal. That was the sort of threshold leading into the sentencing when they had the consultation, number one. Number two, of course, we had the weird circumstance, if you will, that really stuck in Mr. Katsas' mind, which was the government threatening to withdraw the plea on the eve of the plea hearing. And my only point is that—
I just said that is just, neither of those is at all relevant to filing a notice of appeal. And then as counsel would be appointed and the appeal developed, and presumably that counsel would look at the plea agreement.
Sure.
And had they raised ineffective assistance of counsel, I can't imagine what they could have done on sentencing. That was the other out because it was within the limits. But had they raised that, there was zero risk. So I don't know why Mr. Katsas, I can't imagine what possible reason he had for not being more candid in what if he had concerns, to say what they were rather than simply to say, if you appeal unqualifiedly, there could be a withdrawal of the plea agreement. But hey, here's this 2255 thing. You can do it all by yourself without an attorney. It seemed like he was, this is not you, I don't know why I'm saying with you, but it's that he was really trying to steer him to 2255 and away from an appeal, even though ineffective assistance of counsel can be much more effectively raised on direct appeal because you get an attorney. The showing in this circuit is pretty, it's a colorable claim. Maybe he wouldn't have even met that, but that's all that you need to get a remand to develop a record. And so I don't know why any well-advised counsel would not have explained that to their client if, as he seemed to understand, Mr. Hayman wanted to do something more.
Well, he did, no doubt about it, understand that Mr. Hayman wanted to do something more. What Mr.
Katsas understood that Mr. Hayman was not done, that he wanted to do something more with this.
Absolutely. But I think what the record demonstrates is that Mr. Katsas understood that Hayman did not want to do something more within the legal system. That is, he understood, having just decided not to withdraw his plea.
How could he have figured that out?
How
could he have figured out that all he wanted to do, if all he wanted to do was talk to the government, then he wouldn't talk to him about 2255.
Well, again,
he knew he wanted to do something more. I mean, he wanted to try the government route, but it sounded like Mr. Katsas, for a good reason, was skeptical that the government was going to look at that discussion the same way Mr. Hayman was hoping it would turn out.
I don't think Mr. Katsas thought there was much hope. I agree with that.
And so he told him about 2255 as well, because he knew Mr. Hayman wanted to do something about it seemed to be a focus on the 924C. Maybe it was broader than that, but it seemed to be focused on that.
Yeah, well, again, I mean, it is true. There was a discussion of 2255. It was not, as my
There are multiple discussions about 22.
Again, I read the record as demonstrating just twice, and it certainly didn't. Okay. It certainly didn't happen at the time of that final consultation. The record is quite clear on that.
But he got the government not to have a waiver of 2255 in the plea agreement.
Absolutely.
So that was an upfront one, and then the two discussions.
Right.
So all along, Mr. Katsas, is retaining this 2255 right and then talking about this 2250 right, as you said, at least two times.
Sure.
From this record.
I think counsel would be remiss if he didn't make sure that his client understood the options that he had, both direct appeal and 2255, because it was part of the plea agreement. Mm-hmm. I see my time is up.
Can I just get clarity on one thing you said earlier? It sounded like you were saying that the defendant has the burden to show prejudice, which makes sense, but that on the performance prong, the defendant would, I guess, have the burden to show that there was no consultation. But then did you say the government would have the burden to show that there was no duty to consult?
No, I think I'm sorry if I misspoke. I think the burden rests with the defendant to show both that there was a duty to consult, i.e. that he had somehow or another reasonably indicated he wanted to appeal, or that a rational defendant would have wanted to appeal. And that my only point was that both Flores-Ortega and this court has said it will be very rare circumstances when we find no duty to consult.
Okay.
So I don't.
The burden's always with the defendant.
That's my understanding.
Okay. That's what I thought.
And Flores-Ortega is simply applying Strickland, and Strickland is adamant and very clear about that notion. The burden stays with the defendant.
But there's no rare circumstances limitation on the prejudice prong.
Right.
If the defendant had taken an appeal and argued that the legal theory underlying the 924C count was invalid, that would have been a breach of the plea, right?
Yes. I mean, I've certainly never seen a circumstance where the government at that point has swooped in and said you breached the plea agreement. But it's certainly plain language feature of this plea agreement that I suppose the government could have said, okay, you've now briefed this. Unless you retract that, we will find you and we will have a hearing about whether or not you are in breach. And if we find you're in breach, all bets are off.
But any good appellate counsel knows how to deal with that, right? They say counsel was ineffective for not arguing whatever. I think it was Mr. Winstead argued or whatever.
It's an easy end round.
Yes.
But and I'll finish with this point unless the court has any further questions. This gets back to Mr. Katz's warning about the breach. At the time when he's making this, making these decisions and making these providing this information to the defendant, he had just gone through a lengthy period where Mr. Hayman had said, you know what, I want to withdraw my plea. I don't think that 924C is supported by the evidence. That's at the forefront of Mr. Katz's mind when he says to him, look, if that's the theory that you want to pursue on appeal, I should warn you this would be a breach. So it wasn't perfectly articulated like that in the hearing testimony. But again, if you go back to the circumstances facing Mr. Katzhoff at the time he considered what to say to Mr. Hayman, I think that is a significant overlay.
Well, it might be. Those sound like factual questions that need to be resolved. Would need to be resolved were the relevant prongs shown.
Sure.
Right, that's one possible reading of it.
Sure. Okay. I've overstayed my welcome for sure. Unless the court has any further questions, we would ask you affirm the district court.
Well, thank you. It's very helpful. Thank you.
Few points on rebuttal. First, my friend on the other side discussed the appointed counsel's avenues for raising meritorious or non-frivolous grounds for appeal in the 2255 collateral proceeding. But the reality is by the time counsel was appointed for that proceeding, Mr. Hayman was time barred. from introducing any new claims, and the scope of the evidentiary hearing was limited only to one narrow legal issue, which was whether there had been deficient consultation regarding appeal. And so, for all the reasons that were discussed earlier, Mr. Hayman was unable to take the opportunity that he was entitled to have counsel appointed on direct appeal and reassess trial counsel's performance through that avenue. The second,
It sounds like he had, I'm sorry to interrupt, but it sounds like he had at least one other proceeding and maybe some other proceedings ongoing at the same time. We know he had at least a Maryland case going on at the same time as this one.
I believe there was a pending Maryland case, but
Right.
Unfortunately,
That wasn't wrapped up as part of the plea bargain.
no, I don't believe so.
Okay. Sometimes that happens even if it's a state and federal prosecutions, but it wasn't done here by counsel. Maybe it couldn't have. I have no idea. I'm just, perfect. Thank you.
I don't believe so, Your Honor, but I'm not entirely sure. The second point I want to make is about my friend on the other side had argued that trial counsel's raising of 2255 through the ineffective assistance avenue was invoked here only because it was already part of the plea agreement. But if we look to JA 293, trial counsel's own testimony indicates that he raised the possibility of ineffective assistance through 2255 because of the particular facts and conversations that he had had with Mr. Hayman a number of times. And so that reflects his knowledge that Mr. Hayman wanted to do something more, which is also something that the government has recognized. And the duty to consult, as the government has acknowledged, is something that exists in the vast majority of cases and will not exist in only very rare circumstances. And here, given that Mr. Katsas knew Mr. Hayman wanted to do something more, the distinction between those post-sentencing conversations being in a judicial avenue or a non-judicial avenue is irrelevant, given that Mr. Hayman was a lay defendant who was not distinguishing for himself whether he was pursuing a judicial remedy or a non-judicial remedy. He was simply expressing to trial counsel that desire to do something more, and that triggered the duty to consult. And finally, the government has agreed that the information that trial counsel provided was misleading and inaccurate. There was zero risk to Mr. Hayman to file a notice of appeal, given the appeal waiver that was in this case. And ineffective assistance would have been much more effectively raised on direct appeal precisely because of the right to counsel that was afforded in that avenue. And lastly, although there can be overlap in facts between the prejudice prong and the performance prong, they are not coextensive. And the burden to demonstrate a reasonable probability is less than the preponderance of the evidence. And here it is established in the record not only the timely 2255 filing that indicates Mr. Hayman followed trial counsel's advice in raising ineffective assistance of counsel and did so timely, but that he also did so diligently. His attempts to access the law library, as well as his affirmative reach out to the Federal Public Defender's Office, demonstrates his diligence in that regard.
Suppose he had raised ineffective assistance on direct review and won. What would happen at that? Wouldn't that just invalidate the plea agreement and you'd be right back to facing trial with a life sentence?
Yes, Your Honor, it would place him back to the position he was in before that plea was entered. And so with new attorney, he could renegotiate a plea or he could choose to go to trial. And the passage of time has given us a glimpse into the sufficiency of the government's evidence. The lead defendant.
So the downside risk point that he could have ended up much worse off by continuing to litigate would apply regardless of whether he took an appeal directly barred by the plea agreement, like the substantive validity of the 924C charge, or the permitted ineffective assistance appeal, either of which would have just undone the plea agreement.
I guess is the question whether breaching the plea would have equivalent consequences to withdrawing the plea from a
Suppose he
successful...
appeals, if he appealed, he took an ineffective assistance appeal, it's not a breach of the plea agreement, But the consequence of his winning that case is not that he gets to go free. It's that the plea agreement is set aside and he's back facing lifetime in prison.
That's true, Your Honor. But what we don't know based on this record is whether trial counsel engaged in reasonable investigations to test the sufficiency of the government's evidence and whether there were any defenses that Mr. Hayman could have raised on those charges. And the passage of time has given us a glimpse into the sufficiency of the government's evidence. The lead defendant in this purported conspiracy, who the government characterized as existing above Mr. Hayman, was acquitted at trial. And what that demonstrates is all that we do not know about the evidence and about trial counsel's investigations before advising Mr. Hayman to take the plea.
We also know sounds like they wouldn't have 920, or they might not have 924C on the next go around.
That's also true, Your Honor. We simply don't know what investigations trial counsel made into the sufficiency of that charge. The government relies heavily on the statement of facts that Mr. Hayman agreed to as part of the plea agreement to justify that conviction. But if the plea is set aside, he would not be held to the facts that he agreed to in the plea, and it would be the government's burden to establish that conviction beyond a reasonable doubt. If there are no other further questions, we ask that this court reverse and remand with instructions to determine prejudice, or in the alternative, to reverse and remand with instructions to grant. Thank you.
Ms. Yang, you and Ms. Hashimoto were appointed by this court to represent Mr. Hayman in this case, and the court thanks you for your very able assistance. With that, the case is submitted.
Case number 21-1209, International Brotherhood of Boilermakers, Iron Shipbuilders, Blacksmiths, Forgers, and Helpers, Local 627, petitioner, versus National Labor Relations Board. Mr. Rosenfeld for the petitioner, Mr. Heller for the respondent.
David Rosenfeld for the petitioner, second time here. This case has been going on since 2010 when this dispute began. We're only looking for a remand so that the board can reconsider its decision and come up with a more rational explanation of what happened here. I think the board misunderstood to some degree what Section 8F really expects, and that is that if an employer wants to either go non-union, which they're permitted to do, as the open shop, or sign with a different union, there's a process. And there are two cases we cited in the brief that kind of explain and reflect this process, although it was not done correctly by the union involved. And that is if the employer already has a workforce and the employer wants to shift unions, and in that case, it was two employers, Garner Morrison and Raymond Interiors, and they're both cited in the brief, wanted to dump the painters union and go with the carpenters. So they recognized the carpenters, but the important difference was that they didn't destroy, terminate, discharge their workforce. Seamless transition to the carpenters. One day they're represented by the painters, the next day by the carpenters. The problems in the case come from the way the carpenters implemented their agreement because they asserted union security and some other provisions prematurely unlawful. The problem that's in this case. But those two cases illustrate that the proper way to deal with this kind of a transition is you keep the workforce, you apply the new contract, the new terms of the contract. If there's union security, you apply that correctly, and it's a seamless transition without any discharge of the employees.
Doesn't the case boil down to a fact question about why these welders were let go? You say it's because of their union affiliation. The other side says it's because of the 8F policy. It's just a fact question that was resolved against you.
Well, if there is a fact question, the question is, what was the reason for the termination?
Right.
And I think that the board kind of mangled it trying to respond to that question. For example,
You don't think the board answered that question adversely to you? To
No,
your
the board
client?
answered that question adversely, but
On a fact question. That's
Yeah.
what,
but its rationale for accepting it. What the board said was that the employer had a past practice of operating under the terms of a collective bargaining agreement. What the board didn't find, however, and couldn't, was what happened. Did the company have a policy or practice of what happens if there wasn't an agreement in effect? But we do know that the majority in the decision reflects on the fact, because this court said that there were times when the employer had operated without the terms of an agreement, because it kind of said we have a good relationship with unions, we expect there'll be a contract, non-employed agreement. And that testimony is actually Joint Appendix 152 with the president of the company, man Wilson, said, yeah, there have been some times in the past when we've operated without an agreement. And so
I just want, Judge Katz's question, I think, was, do you have any dispute with the board other than over a fact question? And I think the answer is you do not have any dispute with the board other than a fact.
we have lots of disputes about the way they applied the factual findings here in terms of legal analysis of what happens as to why these employees are terminated. And the board's finding was that they were terminated because the employer didn't operate without the terms of an agreement. But we know that that's both inaccurate because there were times when it operated, and we know that
Well, just a little bit more precisely, the board found that the general counsel has failed to demonstrate anti-union motive, which is the essential element of your claim.
and I think the record convincingly demonstrates to the contrary for a number of reasons.
Sure. And I mean, I promise I'll let you argue the facts, but I'm just trying to establish that that's what we're talking about.
But let's look at this gap period argument for a minute. Although fine dredging says we only operate under the terms of an agreement, they don't establish and say what happens if we don't. But what we do know is that every time for the last 25 years, when there's been no work available, there's never been a discharge. It's always been a layoff. And that's reflected in about 15 pages in the joint appendix where we have these employee cards showing their work history. And you'll see some workers going back to the 1990s who were laid off for lack of work, came back, laid off, lack of work. And one kind of irony about this case is when you look at 399, 400, and a couple other places in the record, you'll find that some of these workers were pipe fitters who were laid off and then rehired, laid off and rehired. And then they became Boilermakers and they were laid off and rehired.
The record, at least J155, tells us that what you're calling layoff, they in fact would have to go back through the union hiring hall before they would get dispatched again.
And
Is that
that's
right?
Yes, and that's what was the catch here, Your Honor.
Had they been terminated in this, when you're terminated, you also just have to go back through the union hire. If say a contract ends, you're terminated, you go back through the union hiring hall to get sent back out again under an 8F.
Subject to complying with the hiring hall requirements.
Sure.
And
But you go through, well, that just confirms my point. You have to go through the hiring hall, which means you have to meet hiring hall requirements.
not in a layoff situation.
But they did in this case. That's why I said J155 when they were laid off in previous instances. Layoff meant we were done. We go back to the hiring hall if we're going back
Oh,
out
actually,
again.
no. That meant if you were laid off and you didn't have work for Hawaiian dredging, you could go back to the hall and find work elsewhere. But when Hawaiian dredging laid these workers off, it would often recall them directly because it wanted to keep the same workforce. And that's what sort of animates the.
Where is that in the record?
Pardon?
Where is that fact in the record?
It's not.
That
in
they
the
would
record.
recall them directly rather than the testimony we have that they would go back through the hiring hall.
I thought that was a reference to going back to the hall to look for.
Maybe
other work.
that's what it was. So, but you just made a different representation. I'm wondering where that is.
Because I
in the
don't
record.
think the collective bargaining agreement that's in the record required that in a layoff, the employer had to call the hall because there's nothing on those slips indicating that the hall was called and that they were referred as new hires because they weren't treated as new hires.
I'm sorry, I'm trying one more time. You say the collective bargaining agreement said you don't have to go back through the hiring hall?
I haven't looked at it in a while, but the Boilermaker agreement, which is the one that applied here, did not require that workers went back to the hall to go back to a former employer for whom they'd worked. It did require they go back to the hall to be dispatched to a new employer.
On this point, what do you do with footnote 29 of the board's decision, which says that in this case, there would have been no difference from the worker's perspective between a layoff and a discharge.
Well, there was quite a bit of difference because they were discharged. They had no reason to believe they'd ever go back to wine dredging. They were formally severed. They had no knowledge that they could ever be rehired. And what we do know is that that was contrary to actually what Hawaiian dredging wanted. They wanted to keep the workers. But here, Your Honor, is what happened. The day after they sent the letter of termination, we suspect this was, they knew what was going on here. They're a very experienced construction industry employer. They met with the pipe fitters the next day and said to the pipe fitters, can we rehire, can we bring back our employees? And Reggie Castaneros, the business manager, said, under no circumstances can you do that. And this is what is critical to this case, and which is contrary to the board's finding. The board expressly finds that at no point did he ever say that you had to be a full member of the union, because we know based on union starts and actually an earlier Boilermaker case called Boilermakers Local 749, which this court decided in 72, just before I started practice, that you can't condition referral on membership. You can condition it on other things. And Castaneros says repeatedly that as a condition of these guys getting referred, they have to join the union. Said membership. This is the record at 152. It's at, when this case was pending, Hawaiian Dredging filed a motion for summary judgment and attached Mr. Castaneros' affidavit. It was joint appendix 319. They met the requirements of membership. He states in his application that it would refer all qualified individuals who completed the local 675 membership application process. So they knew from February 18th on that the pipe fitters had imposed an unlawful requirement on rehiring them. And we know that these Boilermakers.
Maybe I'm missing something very basic, but I thought it was just built into 8F that the union and the employer can require workers to be a member of the union as a condition of getting that work.
No, but 8F says, yes, you can condition it, but not initially. You have to let them have this grace period of
7 day grace period.
Right. But the problem was that Mr. Castaneros said unequivocally, both in the trial testimony and his testimony, told the company that on February 18th, subsequent February 23, no, membership application is a condition of referral. We don't allow people to sign up until they've met the application process, they've gone through an interview, and they've passed the welding test.
Right, but that doesn't mean necessarily they had to be sort of full-blown members of the union. That could be that it's allowed in 8F where I'm actually not joining the union, but you have to pay certain fees, and then you go through the hiring hall. And that may have been, it's not crystal clear what the reference, how membership was being used in that letter. Was it could have included both the formal members and the ones who have sort of a membership light with the union because they don't want to be full-fledged members, but still the union has an obligation to let them use the hiring hall and to refer them without discrimination through that hiring hall.
And that's the point the Labor Board makes in its brief, that if you read the collective bargaining agreement, which is in evidence, it suggests that full membership isn't initially required only after 8 days. The problem you have in this case.
Well, it's not even after 8 days. Someone could still say, I just don't like being a member of unions, but I will pay the required fees. And then the pipe fitters, or same for Boilermakers, when they were running the hiring hall, will still have to let them use the hiring hall and refer them through in a non-discriminatory manner, right? Am I right?
Right, you're right.
Okay, so we don't know that that may have been all that was meant by that language.
Well, we do know that because there's a place in the record where when Mr. Castaneros is asked that question in the trial transcript, he says expressly that it includes membership, full membership. That's what he says it means. So I don't know what to do except to say that the pipe fitters understood that to mean full membership and an application. The word application is not a term of art, particularly, or maybe it is a term of art, but application means application to be a member. It doesn't mean application to pay dues and be a non-member. So the word application means I'm joining the union. That's what Union Start says. That's what Boilermakers 749 say. They all say that.
What is the relevance of this, given that there was no agreement with the pipe. I know you think they may have been talking, but that wasn't resolved. That fact wasn't found in your favor. But even assuming it was, there was no agreement yet with the pipe fitters at the time these terminations happened. So we're really looking at Hawaiian, we're not looking at pipe fitters intent. We're looking at Hawaiian dredging's mindset at the time.
Your Honor, that goes back to Garner, Morrison, Raymond, these other cases. Transitions between one union and other union. They're always seamless in the sense that the employees are always offered the opportunity to keep working. Hawaiian dredging, instead of going through that process, which was well known under 8F construction industry, terminated the employees, discharged them, because they knew that the pipe fitters were going to impose this requirement.
That's a fact that is not in the record.
No,
they knew that this was going to happen. It's just that fact hasn't been found for you. So we can't rely on that. And what we can rely on is the fact finding that they were terminated because Hawaiian dredging's work, welding work, had ended.
That's not,
because it didn't have an 8F agreement. It was not doing any welding work, whether it be for a week or a month or a year.
Hawaiian dredging's welding work was still in existence. In fact, the workers themselves closed the jobs down in a way to leave them open to restart them. They took the time to do the right thing and close them down safely. The work was there. It was just Hawaiian dredging chose not to do it. And as I said, the record shows that whenever Hawaiian dredging never ceased doing work, that is ceased operating for whatever reason, it laid workers off to the expectancy of recalling them to bring them back to do that work for other work. And that happens routinely in construction jobs. Material isn't available, weather
You
problems.
said the employees kept working, but actually I thought that there was something in the record about how during some period of time, Hawaii Dredging kept asking Boilermakers to have their employees show up to work, and the Boilermakers kept having their employees not show up.
That's exactly what happened. The Boilermakers didn't believe there was an agreement, so they took job action. And I want to emphasize that that shows union motivation. When the letter was sent to the Boilermakers on February 17th, the company said, we just can't get an agreement. And there are internal memos in the record showing that they were quite dissatisfied with the bargaining strategy.
I appreciate that. Let me ask you a question very much in the abstract, even though I do think this is probably a case about disagreeing with fact finding. Imagine it's not this case. Imagine there's a construction company. I just want you to tell me at the end of this if any of this policy is illegal. Okay? I'm a construction company. I use 8F. I have a policy. I do it for years. Here's what I do. I reach a collective bargaining agreement with a particular union. That union then basically picks which employees show up to work. I basically outsource my hiring to that union. Then that collective bargaining agreement expires. And at that point, I can terminate the bargaining relationship. I stop work. And at that point, there is no work ongoing. There's no work even to be done. I go reach out to a new union. I reach a new collective bargaining with that union. I then start up work on my projects, and that union picks which employees will show up for work. Is anything about that illegal?
That could happen, that if the work totally dried up, basically shut my business down for a while and then signed with a new union, no problem, because I initially discharged my employees saying I've got no work, no prospect of work. But Hawaiian dredging policy, if I may use a few moments, was to operate union, and we're not disputing that. We understood that. But if I'm going to operate union, I'm going to pretty quickly, from February 17th, have a union to operate under to do my welding work, which I paused. So it wasn't a matter that I didn't need the workers. It was that I was just pausing to sign with a new union. But in doing the pausing, I discharged my workers rather than saying to them, we're going to sign with a new union, we're laying you off, you may have work in the future. And what the board says is that the rationale was why they said layoffs were not necessarily appropriate. The board's rationale was unacceptable. They simply said, well, we don't need to, the employer didn't need to explain why layoff versus discharge. That's not a rationale, because we all know, I think, that there's a huge difference to workers whether you're laid off expecting to come back or whether you've been permanently severed and discharged with no expectancy of coming back.
So the fact that the employer discharged rather than laid off, even assuming they have a legitimate policy to operate only under a 8F agreement. Your theory is, well, they didn't have to discharge. That was harsher than necessary, and that tends to show anti-union animus.
Not only harsher, it was inconsistent with past practice, and that's
okay,
what.
but then don't we have to? If that's the theory, there's also a lot of countervailing evidence about the contractors' efforts to bring these workers back, to get them through the pipe fitters testing, to make their facilities available to help that, to try to persuade the pipe fitters to cut some corners on their requirements. Why don't we consider all of that too?
Because the employer wasn't discriminating against the individuals as workers. In fact, the testimony was they wanted to keep the workers. They were the best available. What it shows is discrimination because they discharged them rather than keep them. They discharged them not because the contract terminated. They discharged them because they're going to sign with a new union. And in order to sign with a new union, they had to have a clean deck so that there wasn't this stumbling block of keeping these workers. There's an old board case called Austin and Wolf that cited in the decision in which exactly this happened, where employer terminated people. And the question was whether a new union could say, you have to terminate the employees. We're not going to sign with you.
Yeah, but there the termination was after the new union was in. That's the problem, the difference here. Correct?
I concede, Your Honor, that that is a difference, that it wasn't until the day after they sent the letter that the pipe fitters first said to them clearly they have to be members and they needed to hire through the pipe fitters hall, which meant the Boilermakers who had been discharged would have to wait a considerable period to be rehired. And the record shows it was more than a month before the first former Boilermaker was ever hired. But that was the way that Hawaiian Dredging, experienced in the construction industry, implemented this policy of getting rid of the Boilermakers, which we say they had a right to withdraw recognition. But what Jack Welch, Simcoe, and those other cases teach is you can go non-union. You can go open shop. I don't like that, but you have the right to it. But what you can't do in the process of going open shop, withdrawing recognition from another union, is discharge the employees to effectuate that purpose.
Sure, but they were not going open shop. What you want, it sounds like your argument between layoff and discharge is that they once again should have done what you call one of these gaps. They should have done another one of these gaps that you talked about where they kept hiring or kept on payroll union members, even though they weren't working under an active 8F contract. So you're saying they had other gaps, they should have had another gap here. Is that's what the layoff point is?
I'm not sure it's a gap. What Simcoe teaches.
It would have been another gap. You're saying is they should have, in the bridge between the two contracts.
That's right.
They should have kept the Boilermakers on and working to the extent they had work rather than terminated.
I don't go quite that far.
Okay.
What I think Simcoe teaches is that was a situation where the employer got rid of the IBW, but retained some of them. And the union had said you can retain them all. They retained some, hired some others, and the board found that was all discriminatory. Hawaiian Dredging had several choices. One, keep working, pay them whatever it wanted, and then sign with the pipe fitters, and from that date forward, contract governance. That's what some non-union employers do. The other alternative was to keep the gap, keep the Boilermaker contract in effect, sign with the pipe fitters, and then say, now as of today, you're pipe fitters and you're working under the pipe fit agreement.
They couldn't keep the unilateral. You mean they would unilaterally just continue the prior contract? Is that what you're talking about?
Well, they couldn't terminate the contract with the Boilermakers and continue all of it. They could continue to pay whatever wages they wanted. Once they terminated the agreement with the Boilermakers, from thenceforward, they could keep the Boilermakers welding and say, you can keep working. I'll pay you $80 an hour.
They wouldn't be there for that interim period as 8F employees.
That's right. They would be non-union employees. They could say to the Boilermakers, look, we're not going to fire you.
Right. They would have had to make a departure from their practice.
They would have had to make
like the gaps that you referred to before.
Well, but they would not have had to make a departure from the past practice when there wasn't work available, just laying people off. They could have continued to work. And I think as President Wilson says, they did have some times when there was no agreement in effect and they kind of expected to get one. And I'm not disputing that that's probably what went on here.
Your proposal almost seems discriminatory against the pipe fitters. It's almost like you're saying the law requires the employer to discriminate against the pipe fitters union in favor of the Boilermakers union. Because under your proposal, the pipe fitters would not get to do what they normally do, which is decide who gets the job that day, who's whatever most in seniority or whatever system they have with tests and et cetera. Your proposal would say to the pipe fitters, the Boilermakers get to jump the line, and you have to use them before you start picking which pipe fitters. That seems discriminatory against the pipe fitters union.
Well, that's the way it works. And that's what Austin and Will says, is that the new union can't say to the employer, we will only sign if you terminate the employees so we can then refer our members out of our home. Because that.
But here they were already terminated.
That's right. That, Your Honor,
and you're saying that they weren't allowed to terminate them. They weren't allowed to discharge them. And the effect of that, I think, is because you want to force the employer to force the pipe fitters to let the Boilermakers jump the line.
But it's not jumping the line. It's giving them the right of not being discriminated against because they were Boilermaker members by saying you lose your job because of your membership and you lose your job because we don't like the way your union acted in negotiations. You can't lose their job for it, whether brine dredging chose to sign with the ironworkers, the pipe fitters, the operators, go open shop for a period of time, or re-sign with the Boilermakers. It's just a basic proposition that the workers couldn't lose their jobs because you're choosing to go with another union.
Thank you very much. We'll hear from the board now.
Thank you.
Good morning, Your Honors. Excuse me. Joel Heller from the National Labor Relations Board. After remand from this court, the board followed the court's instructions to consider certain credited evidence in the context of Section 8F. And based on that evidence, the board reasonably concluded that Hawaiian dredging did not violate the NLRA and dismissed the complaint. And most of the arguments the Boilermakers raised on appeal largely address matters not at issue in this case. The matter that is at issue in this case is, as you were saying, Judge Katsas, motive, and motive is a question of fact. Substantial evidence supports the board's factual finding that the employees were discharged because Hawaiian dredging's contract with the Boilermakers had expired, and not because of their Boilermakers status. This was pursuant to Hawaiian dredging's longstanding practice of performing craft work only under a Section 8F collective bargaining agreement. Now, everyone agrees that it was lawful for Hawaiian dredging to terminate its bargaining relationship with the Boilermakers at the end of the contract. And everyone agrees that it was lawful for them, Hawaiian dredging at that point, to cease operating work, or to cease welding work. And that's what they did. And at that point, they had at least temporarily, had no need for these employees. And it was their decision what to do at that point, whether to lay them off, whether to discharge them, until there was a new contract in place. And then they restarted as per their typical
Did the
practice.
board find that they had a business justification for choosing one over the other?
The board found that this policy about only performing work under a CBA was a legitimate business justification supporting the discharge.
How does that support discharge versus layoff? I wasn't clear on that. That's the one thing I'm trying to figure out.
Right. So what
I thought the board sort of said whatever they can choose, or at least the ALJ said they can choose between that.
Essentially, that's
your brief said the same, and I wasn't clear why that's true.
Right. Essentially, that is the case. It is the employer had a choice whether to lay off or discharge because nothing in the NLRA dictates what that choice should be. The cases,
there can't be discrimination.
Right. So long as it is not discriminatory.
But when their letter says, hey, we got to do this because your union won't work with us.
Well, what the
and then we all know they couldn't have been stopping welding for very long. They are a major contractor. So everyone had to know they weren't doing this for long. This was an interim measure.
Yes.
And so why isn't, at least, well, the facts aren't the same as Austin Wolf. Why, help me understand why the discrimination concern, you're discharged because you're Boilermakers. And we're done with Boilermakers. We can't work with Boilermakers leadership. We're going to have to get another union in here. And so you're gone, as opposed to you're laid off. How do we know the Austin Wolf rationale doesn't apply in that context?
Right, and I think it's the point you were making before, is that in Austin Wolf and in the problem was there was something wrong with the new contract. With the new union had made an unlawful request to discharge these employees, but that's not the case here because these employees were all discharged before the new contract was signed. With the
right. So you're saying the board? It seems to me you can abstract out a bit here. It seems to me a little surprising that the board would think there's such a sharp timeline. You know, if it was 5 minutes before we sign with union, I don't want to label the pipe fitters here. So I'm with Union A, not working, can't get to an agreement with them. And so 5 minutes before I sign the agreement with Union B, I discharge all the Union A people. Are we sure that Austin Wolf rationale wouldn't apply in that context?
So it's less a timing issue than it's like, what is the nature of the violation at issue? Because in Austin Wolf,
yeah, but timing can be a fact. Timing and circumstances are a factor in discrimination.
Right, but I guess my point is that whether the question is whether the discharge is unlawful is the question in this case, as opposed to whether the provisions of the new contract are unlawful, whether the discharge is followed.
Well, clearly you could have unlawful conditions in a new contract. That's a separate question.
Exactly.
I'm focused on the scope of the circumstances that the board is willing to consider in its sort of Austin Wolf type analysis. Maybe that one was easy because the union was right there saying, get rid of those people.
Right.
But I assume the board wouldn't be so facile as to say, unless the union's right there on the record saying, get rid of those people, we could never infer discrimination based on how close the timing was between the discharge and the new contract coming in. Is that wrong?
Right, but again, it's the.
Is that right? I mean, they certainly they could.
It would.
On a different record here, and I'm not suggesting this record, but on an appropriate record, they could say, if there's it's a short time gap between the two of them.
Timing is certainly a relevant factor in a discrimination analysis. Yes.
And I would think was it 1 week or less between the firing and the signing? Was it 1 week?
It was 6 days.
Even less than a week. Okay, so it was 6 days.
I believe that.
Difference here. The reason I'm asking this question, so you said timing matters. That's got to be pretty short. That's a pretty fast union negotiation for a new contract. Sure. And so that's why I'm just reacting to your argument that the National Labor Relations Act says nothing about the choice between discharge and layoff, when in fact, I think the National Labor Relations Act says quite clearly, you may not choose discharge over layoff because of union membership. Can we agree on that?
I agree with that.
Right. And so, and then that because of is the motive and becomes the factual inquiry. But that's why I was reacting to and a little curious about why the board was sort of so quick in this. They get to make that decision given the very close, unusually close timing. I know they argue about who knew what when, but you don't even know, 6 days between we're done with your contract and a whole new contract is pretty fast, at least in the cases I have seen. I mean, negotiations can go on for years sometimes. And so it seems to me when they say it didn't matter, that presupposes their answer on this. If there is no discrimination, it may not matter whether you discharge or lay off. Is that right?
Yes.
But they had to make a determination that the reason they chose termination rather than layoff was for a business reason and not a discrimination reason.
True, because
but they didn't find a business reason for the layoff, or I'm sorry, for the discharge rather than layoff. They didn't find discrimination, but they also didn't find a business reason. They left a gap in there.
They did not find a particular business reason. I agree. for doing the discharge versus the layoff. The reasoning is that it is the employer's choice in this circumstance, so long as it's not discriminatory, because the because of question would apply regardless of whether it was a layoff or a discharge. If these individuals had been laid off, we could be up here arguing that, well, this was a discriminatory layoff rather than a discriminatory discharge. The analysis is similar. If they are targeted because of their union activity, it doesn't really matter whether they were targeted as a layoff or targeted as a discharge. And it's also important to note that—
Are layoffs ever worse than discharges?
Are they ever worse than
I'm not sure why it would be a discriminatory layoff rather than you should have fired them.
No, my point was not, yes. I don't think anyone would be arguing that you should have discharged them rather than layoff. But if you had laid them off, there could have been a question, well, you shouldn't have actually taken any action against them. The layoff itself was discriminatory. You should have, there should have been no adverse action against these employees.
I didn't know what all right, well, if your work is stopped, don't you have to do something with them?
Well, that was the board's point here, is that the employer had to do
Okay, so we
something.
didn't have an option C.
I mean, I suppose the employer could have continued paying these employees to not do work, but I'm not sure they would have wanted to do that. And a point, though, about the layoff, one more point about the layoff versus discharge is that what happened here isn't all that different from what happened under other circumstances. The testimony you were pointing to, Judge Millett, at JA 155 of Paul Aona, he testified that in past times when there had been a slowdown in work and they were temporarily let go, but there was no guarantee that they were going to be brought back to be recalled to work. He says that he would, in past instances, he had not been told that he would have been recalled. And then when the time did come to come back to work, he was, quote, redispatched from the union. So that is similar to what has happened in the past. What happened to these employees here is similar to what has happened in the past. And it was again, we're talking about timing, a short break. As soon as this contract was signed, the same day it was signed with the pipe fitters, the employer, Hawaiian Dredging, was reaching out to these former employees and said, we have a new contract. There's a way to come back to work if you want. We don't actually know what it is. You should contact the pipe fitters. And that's another point. These employees were never told that they had to become immediate members of the pipe fitters. They were told by this testimony by the Hawaiian Dredging official, Forrest Ramey, that he didn't actually know what the practice was. They should contact the pipe fitters to find out the process they had to follow to come back to work.
What might be a legitimate business justification for choosing discharge over layoff?
What might, I don't want to speculate too much, but I guess again, this is me speculating. So there might be some.
Well, I'm just trying to, I understand there was no finding. I'm just trying to get a sense of
why.
Does that seem really inexplicable, or does that seem like something one might expect in a situation like this?
Sure. I mean, like we're saying, it hasn't happened in the past, I think, with this employer, as far as we know in the record.
Sorry, what is the it that hasn't happened with this employer in the past?
That employees were discharged at the end of a contract.
You just said that they were discharged. They still had to go. They were discharged, and I'm not sure how this terminology works in the ADF context, but they had to go back. When the contract ended, they had to go back. They were done. They went on unemployment. This is what JA 155 says. Went on unemployment, which I don't think maybe you can do when you're laid off, but you went on unemployment, but had to go back through the union hiring hall for your next job.
Yes, that was in situations where there was no more work. It was not contract expiration situation. So there was still an ongoing contract, but the project had ended. So there was no work for these employees to do. That's what is being discussed at JA 155. And it's so a no work situation is different than a no contract situation, or at least it could be.
So there's different contracts, I guess, at issue. You're talking about the big ADF contract?
The ADF.
When you say no contract, you mean no ADF contract?
I do, right.
Okay, I meant contract.
Oh,
they do contract with other businesses. That's where the work comes from. So okay.
Yes, right. Sorry, that is what I meant.
So the testimony you talk about when they say they get told that they're done, there's no work, go on unemployment, go back to the union hiring hall, is when there was no 8F contract, or when there was no subcontract for these purposes, just to distinguish.
When there was no, I guess, work contract with the client between Hawaiian Dredging and the state of Hawaii or whoever. Rather than situations like here where there was no 8F contract because it had expired.
Mr. Heller, let me
Yes.
try again on
Right, right.
Katsas' question. Imagine you are a screenwriter and you're writing a movie about a law-abiding employer, realistic movie, law-abiding employer, owns a construction company, and ADAP, collective bargaining agreement expires. And in the movie, you write this: I'm choosing to discharge the employees after the expiration of this contract because what's a plausible rest of that sentence?
Right. So the employer could decide it wanted to, if it didn't want these employees anymore. I know, again, that's not the case here, not the facts of this case. But if they didn't want to recall the same employees, they wanted a fresh start. And with a new group of employees, and maybe they didn't like those employees' welding skills, so they wanted someone new. So that would be a plausible explanation for discharge versus layoff. Again, not the facts of this case, but we're not right. So that's how I would answer the question in my.
If they
Bring it
like
up
their
as
welding
straight up.
skills, if they
Right.
like their welding skills, as we know we did here,
Right.
then it still is hard to figure out a business reason for discharge rather than layoff, isn't it?
I was hoping you'd finish the sentence with something that was not inconsistent with facts of this case, because they went out of their way
That's true.
to help these Boilermakers
That is true.
get through the pipe fitting union hall, what do you call it? Hiring hall system.
Hiring hall, yes. So, and if this, I'll keep trying to think of that one, but it may be an unsatisfactory answer, but an answer is that so long as the NLRA doesn't prohibit them from making one choice for the other, they're free to make that choice for whatever reason they would like to. But why did they do it here?
I'm not asking why they did it here, because you
Yeah,
can't read
sorry.
their mind. I'm asking why would a law-abiding
Yes,
employer do it in a way that's not inconsistent with the facts?
Right. So the employer may have thought that, or an employer may have thought that, well, sorry, the employer may have thought that it could have been something having to do with the unemployment situation in Hawaii. Again, I don't know anything about Hawaii unemployment law.
Let me try it. Let me try the same question.
Yeah.
Coming at the opposite end, from the opposite end, the telescope, which is, I'll just stipulate a motive in a hypothetical and tell me whether it's lawful or not, which is the employer sets up the 8F contract. It expires. The employer fully intends and expects that a successor contract with a different union will be put in place in the relatively near future. That's what they want. They're happy with their workers. And the employer chooses discharge over layoff, just to facilitate negotiations of the successor 8F agreement with the new union. Is that impermissible animus against the old union, or is that the employer doing exactly what 8F allows, exactly what's baked into 8F, just to avoid, as Judge Walker said earlier, avoid a sort of hostility or disadvantage to the new union?
I think could be permissible. I'm not saying, I can't say that it would always be permissible. I think it depends. Since it sounds like in this situation that there's kind of some understanding of we have understanding of what's in the new contract. So of course they would
They just think there'll be a new contract in
probably
place in a week, because that's how things work.
right. And there's probably going to be one of these requirements that they get folks to the new union's hiring hall Yeah, I suppose that could be a permissible.
Well, that would
reason.
depend on why they thought it would facilitate contract negotiations.
Right. I mean,
With the next union, right? That could be troublesome.
There's always facts. There's always tricky facts. And we have to figure out whether something is lawful or not.
So, spin that out a little bit. What would be a variation that would
Right.
tend to make it more or less permissible?
Well, I think when we have something like we had here, where there was a requirement they pass a welding test in order to be dispatched by the pipe fitters union. So we're not getting into the sticky area of membership, but we're doing right. There's some other criterion that they have to pass to get get dispatched to the new contract, and I believe it is uncontested that the welding test requirement was fine. I think the Boilermakers say that at page 37 of their brief. So if it's a situation like that, and also like we have here, then I think that could be an explanation.
I thought your original position in the briefs was that there's no practical difference on these facts between discharge and layoff. So it doesn't matter whether they chose discharge over layoff. Is that still the position?
I think that's true. Under the facts of this.
Why do you think that's the case?
Right, because of the point I was making before is that this is actually quite similar to how this has happened, how these things have happened in the past. Admittedly, that's not a 8F contract expiration situation, but the testimony we were discussing before with Paul Iona, where he was saying that in past instances when work had run out, they had been, I'm not sure he uses the word layoff, but or discharged, but they're no longer working for Hawaiian Dredging. They go out on unemployment, and at some point they get redispatched to Hawaiian Dredging. And that's what happened to the employees in this case, just fill in layoff with discharge, because they were discharged on the 17th. They went out. I'm not sure if they collected unemployment, but they were subsequently redispatched, so through the pipe fitters, to work at Hawaiian Dredging. So it's factually very similar to what happened. What would have happened if they had been laid off? They would have been out of work for a little bit, and they would have had to be redispatched to the pipe fitters, and they would have gone back to work at Hawaiian Dredging.
You don't think they were out of work longer as a result of being discharged versus being laid off?
I don't think so, or at least there's nothing in the record to suggest one way or the other. There was some ramp up time to start with the pipe fitters, but I would think, though this is speculation, that would have happened regardless of what had happened, whether the Boilermakers the employees were laid off or discharged, because they would have had to come through the pipe fitters hiring hall. They would have had to pass this welding test, and right, anytime there's, like I was saying, there's kind of a ramp up period, and I think that would have happened either way.
It's true. If you're laid off, you have to go through a hiring hall. I thought the whole point of being laid off in a normal sense, it's not totally clear what that record reference is talking about.
Right.
That it's actually, you just get called back. You don't have to go through the hiring hall. You don't have to do a welding test.
Well, the contract with the pipe fitters says that they have to, I'm not getting the language exactly right, but they have to be.
No, but with the Boilermakers beforehand, if they've been laid off, so they're already employees of Hawaii Dredging if they're just laid off. Why would they need then to even go through the hiring hall? I thought that was the point of the difference between layoff and discharge.
But just going on that testimony from Paul Iona, he uses the word redispatched.
I don't know what that means versus layoff versus discharge. That's the problem.
Well, after whatever happened to him, whether he was laid off or discharged.
I know, but we're talking about whether layoff or discharge matters.
Yes.
So the fact we don't know whether that might have been a discharge.
I don't believe it was a discharge. But I guess perhaps it's true that he doesn't say one way or the other. I don't remember if he says one.
I'm trying to understand what layoff means in the 8F context. Sure. I would have thought, imagine you had a continuing contract, so you're not going between one union and the other. Right. If you're laid off, you go back to the hiring hall, you just go right back to the employers and they go, contract ended, it's Thursday, but we'll see you Monday with a new contract. The new contract starts Monday, don't come to work on Friday because we don't have any work for you. I assume they just show up on Monday, they don't go back to the hiring hall.
That would be my assumption, but I don't.
So layoff could make a difference here.
Well, I think it does matter that there's a new union in. I think that is.
We just don't have a record on this. I don't have any idea how this works. I don't have any facts on this.
We don't have a record on this because it's.
So we don't have a factual basis for saying that layoff versus discharge is the same in this situation. We just don't know.
Okay, let's say we don't know whether, even if we don't know whether they would have been the same. I think it's still the case, however, that, and I apologize, we're kind of going in circles here, but the employer has the choice whether to lay off or discharge.
This is a friendly question.
Yeah.
I thought that the board said in its last decision on review that maybe discharge versus layoff matters in almost every context. But in this context, where an 8F contract, collective bargaining agreement has expired, that there's no continuing contract, that layoff doesn't work any differently than a discharge, because the pipe fitters will still have hiring hall requirements one way or the other, and whether you have laid someone off or discharged them, they're starting in the same place vis-a-vis the eyes of the pipe fitters.
And that's where I was starting at with my response to Judge Millett, that I think it does matter that there's a new union, a new contract, the new union.
And that's what the board said.
Yes.
Right?
Yes.
And there's no evidence to the contrary?
Excuse me. No, there's no evidence to the contrary as to, I mean, the contract with the pipe fitters talks about the employer must secure all employees covered by this agreement through the employment office of the union, of the pipe fitters union. It doesn't make a difference between whether you're recalling them from layoff or whether these are new employees or whether former employees have been discharged.
Does layoff affect seniority?
Does layoff affect seniority?
Assuming that the hiring hall, one of the factors they use for who gets to go out first is seniority.
So are we talking about under the Boilermakers contract or the pipe fitters contract?
Well, either one. You know, I thought there was evidence that one of the factors, at least under the pipe fitters, included seniority.
In the pipe fitters contract, well, 2 points. One is that any seniority accrued under the Boilermakers contract is no more after the startup with the pipe fitters contract. So I don't think
even if you're only laid off by Hawaiian. That's what I'm asking. If you're only laid off by Hawaiian dredging, and that's because it says that in the pipe fitters contract, even if you were laid off by Hawaiian dredging.
Because the contract under which you have accrued the seniority is no more. So your terms and conditions of employment, including seniority, are now governed by a new.
I get that if you're terminated. If I'm still an employee of Hawaiian dredging.
So then let me get to my second answer to your question, is that under the pipe fitters contract, there is a seniority-based dispatch system. Mm-hmm. And what it talks about is it's based on your service with a signatory employer. And so Hawaiian Dredging is now a signatory employer to the pipe fitters contract. So it doesn't talk in terms of seniority with the pipe fitters. It talks about seniority.
So seniority with the company, with Hawaiian Dredging. If you're a current employee, laid off, but you're still a current employee of Hawaiian Dredging, that's going to count towards your seniority.
So I think, one, we're getting farther afield from the record.
Well, it's just that there was an argument that there was no difference here, and yet we're struggling with how we know that. And while the board might have said something, there sounds like, from what you're telling me, we don't actually have a lot in the record. Now, we can argue about whose fault that is that we lack the information in the record, but it's a decision the board made, so it had to have substantial evidence to support its finding. If we had to rely on that there was no difference, if we had to rely on that, there'd have to be substantial evidence, because that finding is very much challenged by petitioners in this case, that there was no difference.
So I think one thing you said is that if you are to rely on that, but I don't think you have to rely on that.
Okay.
Piece, because of the other argument the board's making, that it is the choice, it is the employer's choice whether to discharge or lay off, as long as it is not a discriminatory choice. And if you're with us on that one, I don't think you have to get to the second point about, oh, it doesn't matter whether it's a layoff or discharge. Practically, it's the same thing. I think you could go on either of those theories.
One last question. Is there anything assume that there was a layoff rather than a discharge. Is there anything in 8F that would require the pipe fitters to sort of give more credit to these welders based on that distinction?
Is there anything that would require,
or in the NLRA?
We're talking about like for seniority purposes?
Yeah, for whatever purposes.
Nothing in the statute itself. Nothing in 8F. 8F certainly allows these types of agreements where a new union can come in and require that everyone become dues and fees paying members of that union. If I could just make one more point in response to something that was said earlier, and I'll be quick, is that there's no legal requirement that an employer give these employees an offer that they continue to work during the switchover. The cases that are cited by the Boilermakers in their brief, Jack Welch and all those, it's about the issue there was that the stated reason of the employer for those discharges is that it said, oh, these employees were just going to quit anyway because I know they're not going to work in a non-union shop, and so I fired them. And the board didn't believe that. They said, you can't just make that decision for them. You have to give them the opportunity to quit. And so it was a response to the employer's argument in that case. It wasn't a legal proposition that applies all the time.
Thank you very much.
Thank you.
I think Judge Millett and Judge Katsas, you framed this question perfectly. Judge Katsas, I can see that there are circumstances where an employer could do what you suggest. Say to the workers, I'm pausing my business for a period of time. There's no more work for you. I'm not doing any work. You're discharged, go file for unemployment, go back to your hall, seek work elsewhere, or work non-union. And then at some point, sign an agreement with another union and begin the hiring process again. Judge Millett, on the other hand, points out that in this case, it wasn't a week. It was the next day, on February 18th, that Hawaiian Dredging met with the pipe fitters and began the process of signing the agreement. There were no negotiations. They just signed the association agreement that the pipe fitters had in Hawaii. They signed it a week later with an understanding that if the board reversed the signing, they'd void it. So it's that like instantaneous, but this was a day when they met with the pipe fitters, and we've suggested that they knew before the 18th they were going to meet, but they met that day. They actually reviewed, the record shows, they went to the training center and looked at the training center. The timing makes a lot of difference.
So they went to what center?
The pipe fitters had a very established training center.
Training center.
And so apparently there was a tour given of the training center that very day. They met with the pipe fitters on the 18th. The board's on the 19th, but Valentine says it was the 18th, and then signed the agreement on the 23rd. The timing is important here because discharge meant, to use the term, it facilitated, that is allowed Hawaiian Dredging to sign an agreement with the pipe fitters, which then, I don't say froze up, but preferred all the pipe fitter members were on, as my opponent points out, a seniority-based referral system. I want to be clear about something here, that their referral system favored people who had many hours in the industry and then worked down as sort of seniority system. But I do want to clarify something because I think there is no seniority under the pipe fitters agreement or the Boilermakers agreement in terms of your work. Normally collective bargaining agreements say if you worked for 20 years, you have more seniority over the worker who had 15. There is no seniority. Hawaiian Dredging under pipe fitters or Boilermakers could lay people off without regard to seniority. So the length of time working for Hawaiian Dredging was without a lot of consequence here, except for the fact, this is contrary to what Judge Walker is raising, that Hawaiian Dredging did make every effort to retain these people and asked the pipe fitters to keep them. But Austin Wolf says that the pipe fitters couldn't impose a requirement of discharging or terminating the agreements as a condition of signing an agreement. That, Your Honor, does protect the Section 7 rights of the Boilermakers who had had a union of their choice, or even to be non-union. It protects that right as opposed to a new union that wants to interfere with it.
I'm sorry, so what made this an unfair labor practice was Hawaiian Dredging's effort to get these workers rehired?
No, but what that does is it undermines the argument that they had to discharge them because they had good reason to keep them. They wanted to keep them. It undermines their argument that they didn't just follow some past practice of either laying them off.
Oh, I see.
All right, so it undermines it. And I think that the bottom line from my point of view, if I may conclude, is that when I started this case and I saw a letter that said, back in 2011, 11 years ago, "Dear Union, we're terminating the relationship with you because you've been a bad partner, you haven't negotiated." It sounds like they're terminating the agreement because the union hasn't negotiated. But we know the underlying reason was there were some strikes by the union and the workers. And then the letter said, "And we're not going to hire members of the Boilermakers Union." And that stuck out to me to be an admission that it's a membership-based decision that we're not going to hire Boilermakers anymore. And I think that's what caused this case to kind of have this length of time, because on its face, Hawaiian Dredging's reason is tied to membership, which, as we know in the record, is what happened here.
Mr. Rosenfeld, I know we're long into this argument. I am still confused about practical difference in this specific context between layoff and discharge. Can you tell me where to go in the record where I can see that these Boilermaker employees would have been better off under the pipe fitters hiring hall priority system if they had been laid off rather than discharged?
I can't honestly answer that question because I don't understand the pipe fitter systems and I don't represent them. All I can say is that it does say, counsel for the board points this out, that if you have 10,000 hours working for a signatory, you get a preference. And if they're laid off, arguably that suggests that many of these workers who had many more than 10,000 hours of working for Hawaiian Dredging before it's signed with the pipe fitters would have that preference. I don't know. It's not in the record. It's just speculation on my part. I will concede.
You lose that preference if you're discharged? Because you would still be able to say, I've worked more than 10,000 hours for them.
Right.
That seems key. I mean, that seems to be the key to why in this weird context, this weird fact pattern, there may have been no practical difference between discharge and layoff post collective bargaining agreement with the pipe.
The discharge, the difference was I've been working, some of these workers had worked for Hawaiian Dredging for 25 years, 20 years, 15 years. They're working on projects. They're told they're discharged. They're gone. They have no more employment. Shook your hand. Here's your last paycheck. You're out of here. Because I'm a member of a union. From their perspective, when that happens, they have no choice but to think it's their union membership that has caused their discharge. Now, events later played out that did have an impact because the Boilermakers then later went through the hiring hall process of the pipe fitters, including joining them, didn't start work until March 23rd, I think is the first date. So they lost some time.
There's nothing in the record that shows they would have started on March 13th rather than March 28th if they had been laid off rather than discharged.
There is something in the record because we have the dispatching records from Hawaiian Dredging, and we know they dispatched some of their current members on their out of work list first. And we do know that whatever it took, the first Boilermaker there's some that were on the list before March 23rd, but the date any of them was dispatched was either March 21 or March 23rd.
They still had to pass the pipe fitters test. They still had to do some of these requirements the legality of those requirements is not challenged. There's nothing in the record that says once they checked all the boxes that the pipe fitters require them to check, they would have been able to start earlier than they did if they had been laid off rather than discharged.
That is true from the pipe fitters' point of view, that they would have been on the out of works the same day. But the pipe fitters aren't accused of the unfair labor practice. The accusation here is that Hawaiian Dredging.
I'm just confused. Just to get back to your answer, do we know on this record that if you're laid off, the hiring hall is for new positions. You've got enough existing welders, you don't go to the hiring hall. You've got enough people there already. Do we know maybe this is just how it works. Do we know that if you're laid off, you have to go through the hiring hall, or you just get called back by your employer?
We don't know.
We don't know
We
that.
do not know.
So they might not have had to go through the testing and all that kind of, we just don't know.
No, we do know I'm sorry, maybe I better answer this from two perspectives. We don't know from the Boilermakers in the past whether if wine dredging laid me off
I don't
today.
care about the Boilermakers. What I want to know is in this situation, if they had laid them off when their work ended, because they expected to have work again within a week or two, they had laid them off rather than discharged. Would they have, I had thought from your, maybe I just misread your brief, I had thought the point was you wouldn't have to go through all this rigmarole with pipe fitters if you had just been laid off, because you would already be an employee of Hawaiian Dredging. No reason to go to the hiring hall. We have folks on board already. Maybe they have to go ahead and do some paperwork with them, pay some fees or something, but they wouldn't have to get cleared through a hiring hall. The hiring hall is for new needs, not when your existing needs aren't filled.
Our position is Austin and Wolf, that if the company.
No, what is your actual answer? I don't want a legal answer. Austin Wolf doesn't tell me about this.
Factually, no. Factually, if the company had laid them off, the pipe fitters from day one insisted that layoff or discharge makes no difference to us. You still have to join the.
Would that have been lawful?
It would have been lawful if they were not, had no expectation of employment, had not been discharged, for the pipe fitters to say any new employees have to go through our referral system.
Right, but if you're laid off, you're not a new employee. That's where I'm confused.
All right, so the difference here is that Hawaiian Dredging could on the 17th, whenever they drafted the letter, they knew on the 15th actually that it had been dismissed because that's the date that Barry Marr's office received it. But they could have said to these workers, we're going in a new direction. You're all being laid off. We are not going to work until we sign a new agreement.
But you're arguing for this, right? Your brief is that they should have been laid off, not discharged. So your argument is that, okay, so they would have said that to them. And then,
because in this fact pattern, as they laid them off, they would be saying to them, we're not getting rid of you permanently. We're not saying you're done with Hawaiian Dredging. We're just saying we're going a new direction. And in fact, we're going to sign with someone else, and then we'll deal with rehiring you. And then the question is, what would the pipe fitters have done? If the pipe fitters had said, okay, anyone who's in layoff can come back first. We'll let them go back to work. Or the pipe fitters could have said, sorry, you can't rehire them because you've got to go through our system again. And that's what Austin Wolf says, Judge Walker, that the pipe fitters can't do. They can't or cannot. They cannot. They cannot say to an employer, you've got workers who are currently working or laid off, you have to fire them, give preference to our people.
that seems like a simple answer to my question, which is, had they been laid off, as a matter of law, they wouldn't have had to go to the pipe fitters hiring hall.
The pipe fitters would have insisted they go through the hall, yes.
But that would have been unlawful.
Yes.
All I'm asking you is, as a matter of law, they would not have had to go through the hiring hall.
No, not, I'm sorry. As a matter of law.
The law wouldn't have allowed the pipe fitters to say you still have to go through our hiring hall. I assume that's what you're the one who raised this layoff. They should have been layoffed rather than discharged. You must have done it for a reason.
Yes, yes. Austin and Wolf says you can't discriminate by having a new union condition employment on current employees or laid off employees by going through the hiring hall. You cannot condition that. And that's what Austin and Wolf says, and has been reaffirmed since then, that the new union can't say you got a group of workers, you got to discharge them in preference to our members. You got a group laid off, you can't disadvantage them in preference to our members who are referred to displace them.
All right. You sure?
I'm sure.
Okay. Thank you very much.
Yeah, thank you very much.
I'm sorry, that case is submitted.
What
Boilermakers cases.
Yeah, seemed like they were standing around.
Oh.
Case number 20-5350 et al. Pomona Valley Hospital Medical Center versus Xavier Becerra, Secretary, U.S. Department of Health and Human Services, appellant. Ms. Marcus for the appellant, cross-appellee Alex Azar. Mr. Collins for the appellee, cross-appellant, Pomona Valley Hospital Medical Center.
Thank you. Good morning. I'm Stephanie Marcus from the Department of Justice, and I represent appellant cross-appellee, the Secretary of HHS. In this case, the district court erred by holding that the final decision of the agency, here the decision of the Provider Reimbursement Review Board, was not supported by substantial evidence. The board was addressing a challenge by plaintiff Pomona Valley Hospital to Medicare payments known as disproportionate share hospital or DSH payments for 3 cost years. Specifically, Pomona is challenging the Secretary's determination of the number of its patient days attributable to Medicare beneficiaries who were also entitled to SSI. That determination is governed by a 2010 notice and comment rulemaking that Pomona is not disputing applies here, and that fully set forth the Secretary's methodology and data and a revised matching process for how the Secretary determines which Medicare beneficiaries are also entitled to SSI. And here, the board properly discussed the regulation and relied on it for CMS's process of calculating the numerator of the Medicare fraction. The district court, in contrast, erred by holding that the regulation was irrelevant, essentially, that it was going to look at whether the board decision was supported by substantial evidence. But the error is in making that inquiry, the regulation governs that the board's determination and is part of the substantial evidence.
A methodology can be misapplied.
Yes.
Right?
Right.
And so Pomona could come to the board and say, we have no beef with the 2010 methodology, but we think due to human error, it was misapplied. That's not a challenge to the 2010 methodology, correct?
Correct.
And in that instance, Chevron would have nothing to say about the outcome of that case, correct?
Correct. However,
why is this not that case?
Because here, the question would be whether they then submitted substantial evidence showing that there was some error in the process or that there was something wrong. And here the board issued an extremely thorough decision, record-based decision.
Thorough.
We have cited numerous places in the record where the board found discrepancies in the data that Pomona asserted was congruent with
So to me, that's where the rubber hits the road, but it has nothing to do with whether the 2010 methodology is sound. And so therefore, there's no legal challenge to the 2010 methodology. And Chevron doesn't tell us anything about whether substantial evidence supported the board's, CMS's application of the 2010 methodology. So far, so good?
Maybe, Your Honor. I mean, again, it's not a challenge to the regulation. I agree with that. And therefore, we're not using Chevron to see whether you should defer to the Secretary's interpretation because Pomona is accepting that for this case. But where the problem here with the District Court Pomona's analysis is that when you have a regulation like that isn't being challenged, the District Court in Pomona essentially puts CMS in a worse position. And had it not had it says, oh, we're going to shift the burden of proof that ordinarily applies in board proceedings pursuant to agency regulations. And for example, and here the Secretary, the main DC Circuit opinion that the the district court relied on in shifting the burden to the secretary is Atlanta College of Medicine. And that one, the DC Circuit first found that on Chevron 1 basis, the secretary's interpretation was contrary to the statute. And then it actually expressed sympathy with the secretary's administrative concerns and said, and under the circumstances, it would seem quite reasonable for the secretary to adopt regulations or even adjudicatory presumptions as to what a school must show.
And I might,
sorry, I'm on the same line. The district court probably overstated in saying that, did overstate to the extent it said that the regulation has nothing to do with anything here, right? But we're reviewing de novo.
Yes.
And it seems like we all agree that the regulation structures the inquiry and that Pomona is arguing that not that the regulation is wrong, but that for whatever reason it was misapplied here, right?
And the problem then is you get to the evidence Pomona presented to the board.
let me walk through the evidence and you tell me where I'm not thinking about this. Pomona puts forth this evidence, preponderance the evidence standard, so they don't have to prove beyond a reasonable doubt that their amount is the perfect amount. They don't have to prove that beyond a reasonable doubt. They have to prove beyond a preponderance of the evidence. They put forth expert testimony. They use the Medi-Cal data, et cetera, et cetera. And the government comes back and says there's three problems. Number one, some of that Medi-Cal data is including people only get state and not. To which Pomona comes back and says, okay, we'll adjust according to how you tell us to adjust. So by the time the rebriefing is done, the post-hearing briefing, that error is no longer an error. And then the government has identified two other errors, one to do with nursing homes and one to do with what time in the month the person is signed up. And Pomona has expert testimony that says those errors are statistically insignificant, which the government responds with no expert testimony. And the government has this kind of fourth category of, well, because of these first three errors, there might be some more errors. They don't identify any of them. Now, is that, I know I've described the case in a way that you probably don't like the slant of it, but what's factually wrong about what I just said?
What's wrong, Your Honor, respectfully, is that Pomona, remember, is not challenging a rulemaking which Pomona had a chance to make comments on, other providers did, and that rulemaking established the best available data for the inquiry. This makes a lot of sense. You're trying to determine who is entitled to supplemental security income, a federal benefits program, and CMS uses SSA data. That's where they get the data. Pomona comes, there's a very high, you can't have providers come forward with data from 50 different states. And here, Pomona was trying to show congruence, right, with its data and Social Security Administrative data, and it simply didn't show that. It would have to show that to meet its burden. And in fact, the state supplemental payment only issue, Pomona didn't correct till after the hearing, after it was pointed out.
If there's no problem with the data, let's assume that, but let's imagine a case much like this, but we'll assume in that case, human error, data entry was the cause of a vast discrepancy between what was paid and what should have been paid.
Well, on the one hand, Pomona also agrees that the best available data is the correct legal standard, and under that does allow for errors. It doesn't require perfect accuracy. And so what a hospital would need to show is that if they're not challenging CMS's determination of the best possible data, that for some reason, because of application of the process, CMS didn't actually use the data it was saying it was using, and it simply is enough legally.
It's not so much that you all didn't use it. I mean, this happened, I think, in California, where a computer just didn't read the bottom half of a spreadsheet, right? You could have, when we talk about human error, I think we need to include computer error. And so what they're trying to show is something went wrong here. And so, yeah, we get writ large, that's fine. Your methodology is fine. We're not challenging it. But even in the rule, you acknowledge that, look, you could still have what I will call an as-applied challenge, that something went, not to the rule, but an as-applied challenge to what happened here, whether it's input or the computer just didn't read, it was two-sided information that only went one side. That challenge could be brought.
Yes.
And how would they prove that challenge? Since they don't have those files, they go, well, look, MedCal says we're off by 25% here in our numbers. So something went wrong. Would that be an appropriate, if you just came in and you said, I'm hypothesizing that what happened is the computer didn't read the flip side of the document for some reason. And so it only got part of the data. It didn't get all of the data in, even though everyone tried their best and applied the methodology. And the way they were able to prove this gap is they went to MedCal or whatever documentation they use, and it shows we got a 25% gap between who's eligible on these records and who's eligible there. Now, it may be the secretary will have an explanation, but they've shown a 25% gap. And so something went haywire in the process. Why isn't that the type of challenge that the rule reserved?
That type of challenge, Your Honor, can be brought. And we've said that. We are not alleging that the process is infallible or unreviewable. Here, the problem is in the data itself, which the board thoroughly showed that it's not congruent. The 8 codes in California don't match up one-to-one, and they gave Pomona a chance to put forward evidence about what those 8 codes meant, 10, 20, and 60, and to show that they weren't.
I thought they showed that it meant age, blind, and disabled.
They did, but that could be far more broader.
But those are their people that are getting SSI. If we back out the supplemental people, that's their people who are getting the SSI.
They actually did not show that, Your Honor, with all due respect. What they say in their reply brief is that over 90% of the SSI entitled people that were shown in the MedCar Section 951 data CMS did give them, that was 96% of those go into the 10, 20, 60. But what they didn't show is who else is in the 10, 20, 60. There are a number of those people we already know. State supplemental payment only eliminated over 50% of their claim days in one of the years.
What did?
The state, the SSP.
The adjustment for SSP.
Yes, yeah. And that was a very significant adjustment.
They made the adjustment.
But I wanted to get back to your question about a challenge, with the computer error, some really major error. The MedCard data does give that the secretary did provide here and did in accordance with another rulemaking that's not being challenged and explains what data secretary can and will give the hospital. If they get that data shows them the patient days to which it's the same entitlement data for their patients, like which of their patients were entitled to SSI. If they claim like 2,000 patient days and the MedCard comes back and shows that 1,500 of them were entitled to SSI, and then in their Medicare fraction, for some reason, the agency just left out, half of the patient days that its own data showed were included. That would be, a way of showing an error because they're using the data that CMS itself used in the process. But there was,
they don't have the SSI.
They do. Well, what they have, Your Honor, is they
have MedCar, which is some sort of aggregate SSI measure. I've forgotten, month by month or something.
It does, and it does show that hospitals would be able to show which would be able to determine based on that which of their patients were deemed entitled to SSI. And that's what CMS gets from the Social Security Administration.
But they also get the SSI, right? Which is, as I understand it, way more granular, patient by patient, right?
If the SSI
The kind
file-
of data that might show the counting errors, the coding errors, the human errors.
Your Honor, the SSI eligibility file is, right, and you're right, that isn't turned over to the hospitals because it contains a lot of privacy information because it's
Sure.
it's for a month, it's for thousands of hospitals, not just Pomona. The agency can't just turn over the file because they're giving like in 15 months period.
You may well have very good privacy and administrability reasons for not giving out that massive dump of data, but it puts the hospitals in a tough position when they're facing numbers that just don't look right, and they have a burden of proof to try to explain why.
But,
So what else could they do other than try to reverse engineer through something like Medi-Cal?
They can use that information to reverse engineer, and to some extent, to a large extent, this is because of how Congress has set up the DISH formula itself by making the number dependent on SSI.
You say they can reverse engineer.
Yes, with the med part.
And here they did reverse engineer. You pointed to 3 problems with how they reverse engineer. They fixed the first problem with regard to the supplemental state stuff. And the other 2 problems, the expert witnesses testified, were statistically insignificant. So it seems like they reversed engineered pretty well. Maybe not perfectly, but beyond a preponderance of evidence, pretty well.
Can I add one fact that they found still a 20 to 25% gap between your counting and Medi-Cal, right? Wait. Right. So I'm just adding that in. So it wasn't that they found you were off by 5 people, which would go to your administrability point or your non-perfection point. So even after supplemental payments are backed out, there's a 20 to 25% gap, even though there's a 96% gap, as you pointed out, between whom we're counting, right? The patients we're counting.
Oh, no, there's not. No, I was just trying to refute their point that the people who are entitled, and everyone agrees are entitled.
Right. And they found 96 or 97% overlap between who Medi-Cal's counting. This is their expert testimony. Maybe an answer to it, but their expert testimony was we got 96%. I think it was 96, 97 between who you're counting. You can explain this. Maybe this is what the board could have explained, but they didn't say this. Whatever you're about to say, I don't think they would have said it unless you can tell me where they said it. We got this many people. So Medi-Cal, there may be counting a few people they shouldn't even now that we've taken out the supplemental SSI. But there's a huge amount of overlap, and yet we're having a 20 to 25% gap in patient days that are being counted. So that's
I apologize, but
I don't mean to hijack your question.
I think it's not an overlap. I think it's what they're saying is of the days that CMS agrees and they got credit for, those went within one of those 3 codes. What the board was asking them to do was to do a ratchet back the other way and show us, okay, so we know your 3 codes, yes, they include the SSI entitled, but they include, we don't know how many other patients included in those codes. Like you showing us a 25% disparity between Medi-Cal and our calculation doesn't show anything unless you can show a congruence in the data, which they didn't show. They gave them the opportunity to do the crosswalk. I mean, that, I think.
Which the board said, like, we know you probably can't do this. That doesn't seem, incredibly hard to do, but you should have at least tried. But they said that the only reasons they gave for thinking that there's a big gap is nursing home and the shifting eligibility date, which I'm not sure is going to matter because someone's going to be coming in each time. And they had expert testimony. I'm just repeating what my colleagues have said. Expert testimony said that statistic, that's not going to explain the 20 to 25% difference. And the board saying, well, maybe you could have tried a crosswalk. I'm still not sure how that is responsive. What evidence the secretary put in or what evidence was in the record that would allow a court to say the absence of the crosswalk provided substantial evidence that their 20 to 25% gap was off. I didn't even hear the board saying we don't understand what those codes are. Those codes are age, blind, and disabled.
But what the board did say is we don't know if they have aged, blind, and disabled people in their state category who are not entitled to SSI as defined in the rulemaking. That's what the board was saying, and there was testimony about the minimal discrepancy, but the board pointed out that the information about those other two discrepancies was available to Pomona through the Medi-Cal data it has. That was its data. It could determine how, instead of speculating about how many patients statewide are in nursing homes, it could actually look at its patient data, come back to the board and quantify it. But more importantly, the crosswalk.
Its expert did testify about sort of percentages and small percentages and how this isn't going to, the nursing home, it's a very small number who are going to fall into the problem. And as to the eligibility, they said, look, this is going to be quite the rare bird when someone is, getting Med-Cal but not getting SSI all within the same 4-week period. And none of that was rebutted. Had the secretary rebutted it, we'd have the board, there'd be something to work with. But how, when that's not rebutted by the secretary?
It's because and this is where the non-consideration of the rule plays in. That is a reason other than the sufficiency of the evidence. The secretary discussed administrative finality. It discussed not having providers use 50 different sets of data. We have to have one set of data that we use. If a provider comes forward and doesn't show congruence with that data, that's a problem.
Why is to show congruence? Why wasn't it good enough they have two experts who seem pretty credible on their face, right? Well, one person ran Medi-Cal and one person ran the office in CMS that does this DHS stuff. And they said, we've looked at everything and we can't imagine any explanation for the 25% gap.
Again, that is not quantifiable evidence in the record. And if they had an expert like that, presumably they could at least give the board a definition about what those codes meant, what people were included. And the board did ask some questions at the hearing and pointed out the rulemaking went through a list of codes that SSA uses that do not denote entitlement. And the CMS explains why it doesn't use those. And that was another example that could be a discrepancy with a state program. And
you're right. Perhaps they could have put on better case had they run the ground codes. And I'll ask your friend on the other side. But it seems like they still put on a pretty good case through these pretty credible experts. And the government's response was nothing. And, not to be flip, but doesn't something usually beat nothing?
Again, Your Honor, with all due respect, it isn't nothing because there is a rulemaking that governs this process that very carefully went through the data. And the contractor that doesn't address the miscounting or miscalculation. But they haven't showed any miscounting because the expert declaration they rely on is someone who's talking about Medi-Cal. Nonetheless, he made a big mistake before the hearing about what the Medi-Cal codes meant. They were going to senators and congressmen when almost half their days were SSP only days. I think
is there any reason in the record to believe that there's another material gap between what Med-Cal includes and what SSI covers? I had sort of thought the 96% congruence helped.
Oh no, and again, Your Honor, I
take that aside. Then what is in the record that shows? I get why their own state payments, right? We don't want to count those, and those are backed out.
Right.
And I didn't see the board saying that wasn't backed out in an accurate way. It just talked about it like it hadn't been backed out. So what else, what basis is there in the board decision for thinking that there is a material gap between, with that backed out, between the codes that California is using for the purpose of administering SSI payments and what's used, the codes that are used by SSI? That's where I'm not getting. I mean, you say there could be some other gap, but how do we know there's a material gap?
We don't know, but it's the hospital's burden, and that's the hospital's burden of production, and the board found it did not meet it here. And these, the discrepancies the board did find.
No, you guys work with California, right? Why is there, on what basis in their statute, their rules, or anything that's publicly available is there for thinking that they're including anybody else that isn't an SSI person here? What basis is there for that? Given their definition, given the whole point of having these codes, given the point of what they're measuring, SSI eligibility, that's their goal, is to, these codes, they say, measure SSI eligibility, back out the supplemental payments.
Well,
what basis?
For example, the chairman of the board in, this is on JA page 208, it's talking about asking Pomona to do the crosswalk. And he says things, there are codes in the Federal Register that are, some of them are actually suspension of payments. And you can look at the Federal Register. We have it in our
I'm sorry, this is JA where?
208.
So it's not in the decision of the board.
No, but the
Okay, where in the decision of the board?
Okay.
So I think that's what we're reviewing, right?
Yes.
We don't review the hearing transcript.
Yes.
Is there evidence of material difference?
Your Honor, apologies, but the board on JA 44, the board referred to the hearing and said, during the hearing, the board pointed to other reasons of why variances may exist between the 8 codes used by Pomona and SSI codes. And then they talk about the ones they did, specifically identify, but I was trying to show in the hearing record.
Right, and those
yeah,
we're taking, at least at this point on the record evidence, are not material ones. So I'm sorry, I just kind of figure if in their decision, they're going to pick their 2 best.
Okay,
Am I wrong about that? Would they pick their 2 worst? I think they would reference their 2 best.
Well, I think they picked ones where where through their questioning, without, Pomona made an affirmative showing, and the board, through their questioning at the hearing, recognized just from the affirmative showing that these 3 discrepancies. That's pretty significant.
One of which was fixed and 2 of which were not material.
So, and then they then said in their decision, and this is JA 46, at the hearing, the board specifically requested a diagram of how information from SSA is translated into the aid codes, and in order to gain insight on how these relate to CO1, MO1, and MO2, it says this, and further it says this question remains unanswered as Pomona did not submit any additional information. The board acknowledges that building a crosswalk might be difficult, but it's necessary to know whether 10, 20, and 60 accurately identified only those individuals with an SSI code. So
is there anywhere a public definition of these codes?
There's not a definition. They did a flow chart of sort of the process of how the agency gets the data, which, as we pointed out, and again, this isn't in the board's decision, but it can just, the board did a couple times reference finding these 3 discrepancies made it concerned that there could be other discrepancies, and Pomona has the burden to show that is not the case. And there could be timing discrepancies. If you look at the flow charts, they get this data weekly. SSA, the CMS pulls the data as it shows in the rulemaking at very specific times. So they're not a
related thing. I noticed that I could have just missed it, so please tell me. In the rule, it defined what for the federal codes, CO1 meant. But I didn't see where MO1 and MO2 are defined. Are they defined in the rule or somewhere else?
They are both. All 3 mean they're entitled to SSI. I don't recall seeing it defined in the rule.
So what's the point of figuring out what 10, 20, and 60 mean if there's nothing that I could see in the rule that says what there's no point in doing a crosswalk if you don't know what the end of the crosswalk is, what MO1 and MO2 are, unless it means aged, blind, disabled, and the California codes are age blind disabled.
Again, the MedCard data shows, it provides to the hospital which patient days were identified as MO1, MO2, CO1, the three entitlements.
But it doesn't, no, the whole point of the crosswalk is you have your codes, California 10/2060.
Right.
And you need to match them up to CO1, MO1, MO2.
Right.
Okay. Let's say they had all the information in the world about 10/2060, is that right? Yeah, 10/2060. But they don't know what MO1 and MO2 cover. You can't do a crosswalk.
Actually, I think the main issue with the crosswalk here is not determining, since all of the entitled data did translate into 10, 20, and 60, 96% did. And as we noted in our brief, Pomona, that didn't stop Pomona from taking the other ones that CMS credited them with that weren't in 10, 20, and 60 and keeping those in the total. But what they want to know is what 10, 20, and 60 encompass, so we can see if there is anything in there that would map into something that's not MO1. And I think that data.
How would they find that?
They could ask. I think it is available publicly. It's not in the rulemaking, but it's probably, I don't know exactly where, but there was, as the board.
Wouldn't the board have to know that this is something they could find?
I think it does. It said it could consult someone from SSA, and that's not privacy information, what the codes mean. The rulemaking does go through a lot of what the codes unentitled
Sorry,
to
SSI where does it say they can get this definition?
It says by obtaining the definitions of the various codes.
Where?
And I'm sorry, this is on page.
No, I'm sorry. I'm sorry. Yeah, I'm on page 46 with you. I'm like,
yes.
Where do they obtain it? Because if this is public record information, then the board would have had it too.
But again, first of all, they didn't even show what their codes meant. Presumably, they have access to what the Medi-Cal codes mean. That would give you a really good idea when the agency has very carefully defined what entitled to SSI means. It means receiving payments. And the agency also went through a number of codes which various providers during the rulemaking said, you really should include this other code. So that information is out there and available to providers, or a provider wouldn't have given, presumably CMS.
I guess I didn't see in the rule what MO1 and MO2 means.
Yeah.
I still find that quite troubling on its own end. But anyhow, they're supposed to go find what 10, 20, 60 mean in California. That's the problem. So if they come back with that definition and they say it means age blind and disabled within the meaning of the Social Security Act, so that you're eligible for SSI.
Entitled in the meaning, and that they are
receiving payment, SSI
receiving payments, right? I mean, but I don't.
If they come back and the definition is receiving federal SSI payments.
I mean, there still might be other problems with timing. I think here they didn't come close.
No, but the timing thing is one of the things that was flagged here, and that was the expert said it's not going to make.
I'm sorry. I mean, the timing of when the data itself is pulled, because if Medi-Cal data is being pulled every week, that's different from what the agency said in the rulemaking.
But that timing issue was in reference by the board, though. The board doesn't talk about that type of timing one. I mean, that's right. Information you have, which is helpful, but the secretary didn't put that in.
But what the board did say is there could be other discrepancies, and Pomona.
Let's say if they come back, I'm sorry to ask you to speculate, but just to try to understand the theory here. If they were to come back and say 10, 20, 60, we're going to back out the nursing home, guess what? It doesn't matter. And we're going to back out the eligibility dates, the difference between California and SSI, the sort of 1 month gap.
And
guess what? It did. And they actually did it. They're actually doing both. So they come back, they do that, and they do the same thing for nursing home. Instead of having the experts say it's not going to be statistically relevant, they do the math. It turns out it's not statistically relevant, but they back those out. And they do the same for the timing. And they say, well, here's your definition of 10, 20, 60, and it means receiving SSI. It means receiving SSI within the meaning of the Social Security Administration. All right, and then would it be sufficient for the board to go, well, there could be other things? other
Your
problems?
Honor, I don't, I mean, that's.
It seems like you're putting a lot of weight on that language, and so I'm trying to figure out, is the problem here that because they didn't do B and C, or A, B, and put aside the supplemental payments, A, B, and C, they didn't do nursing home, they didn't do the difference in eligibility, dates, and they didn't give us a definition of 1026
To
days.
show that, and show that that would correspond to what entitled to SSI means.
Right, and if they come back with that, then it would not be sufficient for the board to go, well, there could be other problems.
I mean, I think it would depend, and the board couldn't, I think at that point, maybe the board couldn't just say there could be other problems, but I mean, I think there would, what the board is saying here is what you didn't meet the burden of production to make the agency produce evidence when it has this rulemaking that you are just, you're providing your own data, which isn't what the,
And if they had
and it doesn't show that the agency didn't use the best available data. It doesn't, and inaccuracy isn't enough. And it didn't even show inaccuracy. It's unreliable. It really, the board showed how it was unreliable. So yes, you'd have a different case. I don't want to speculate what would happen then because you'd have an entirely different case, and I don't know what the board would do with, whether the board would ask for additional evidence.
To follow up on it, why should we care about the nursing home and the difference in eligibility dates referenced by the board here? Since they had unrebutted expert testimony that said those are statistically insignificant. Why should those matter at all? And then the board just says, well, there could be other things.
Actually, the board didn't just say there could be other things. The board said, okay, maybe you think it would be statistically insignificant, but maybe, if Pomona didn't, if this wasn't a huge number of patient days, and one of their patients who was in the hospital for 30 days in 1 month, there is evidence in, this is on JA 109 about when Pomona was sending an email asking about, or would the Medi-Cal codes also show not entitled if someone's in a nursing home? And the person says that a recipient going into long-term care would stay in aid codes 10, 20, or 60 for 3 months. So what the board is saying, it may be statistically insignificant on a huge statewide basis, but you go back to your data, you tell us about your patients. Were any of them in a nursing home? And Pomona didn't do that. And Pomona also didn't go back and look at when, their own patients went, because the SSI.
Are you arguing that it might be statistically significant? Is that the point you're making?
I'm just saying that the board gave Pomona the opportunity to quantify with respect to its own case.
It is statistically significant, it's not statistically significant, and it might be statistically significant. Which of those three are you arguing?
I think I'm arguing with respect to Pomona, it might be. We don't know that. And that they had the chance to go back and look at their own data.
But what we know, all we know is what the record shows. And what the record shows is that it's statistically insignificant, and that's not rebutted. So how can we say we don't know there could be a material difference?
Again, going back to what the board asked the Pomona to do, here it says, and actually Pomona didn't provide an estimate of the impact of this difference on the additional SSI days being requested. The board does not and cannot know the significance. So it says they didn't even quantify from their own record the number of additional days being requested that were patients that came to Pomona from a nursing home.
Sorry, what line are you referring to at this point?
It's on JA 44, the penultimate line, the last sentence starting with however. So what they did is they submitted statewide statistics, but the board is saying they could have gone back and done it for their own data, for their own patients.
Pomona specific patients.
Yes.
Is there any reason to think that there's something unusual about Pomona?
I don't know, but that again, it's their burden.
That would have been a great argument for the secretary to have put into the record. Is your experts say this, but hospitals can be very different based on their patient population. And so what's generally statistically significant might not apply to an individual. But I don't have any reason for thinking that the general statistics don't apply with equal force to Pomona statistics. Is there, I don't know how this operates. Maybe there's some reason.
I think it's because of rulemaking is a presumption that you use, the MedPAR and the SSA data, not state data, to make this determination. So there's
no one's asking you to use this data to make a determination. Are you trying to you're not saying you need to use Med-Cal data. They're saying Med-Cal data makes us go, uh-oh, something went wrong. Right? I don't think, maybe they'll say otherwise. I don't think they're saying you guys have to run this with Med-Cal data. They're saying something went wrong here. And they've made a showing. And so far it sounds like you want them to go back and show that what unrebutted testimony that was statistically insignificant, you just want to run the numbers.
I think there is a high burden in the face of the rulemaking and administrative finality that to show there actually was a problem in the application of the process.
It's preponderance of the evidence. That's the burden.
I'm sorry, Your Honor?
Is the burden preponderance of the evidence?
Yes.
It's not that high.
But it's a preponderance or is it a substantial evidence?
Well, your standard review is substantial
right,
evidence. Okay. And I think that here you're
there's a little difference. Is there substantial evidence that the board thought there was a preponderance? Not that there was not a preponderance. Right. Is that still listing?
Yes.
I don't know if that's the thing.
Can I ask something unrelated, not unrelated to the case, but why didn't you just accept the invitation to run a test on the small sample unmatched?
Your Honor, because that, I think, with the agency not seeing the data, sufficient data to show there was any error, it does not have the resources to perform ad hoc.
Again, it can't just do it every time a hospital comes along. But here, there's a lot of evidence that there's a lot that might be wrong.
We respectfully think there isn't a lot of evidence here and that they didn't make, but that said, it is, even doing a sampling involves another agency, the SSA, and they have privacy protected, HIPAA protected in some instances, underlying data about why someone, the specific reason. Like the hospital can deduce from MedPAR which of its days were determined to be entitled to SSI and which weren't. What it doesn't know is why weren't they, right? And so that's the sampling would go back and look at that, but CMS has, an agreement with SSA to specifically use this information just for, and CMS doesn't even get those underlying codes. So it would need to go to SSA and do a whole, separate agreement and if
I thought SSA was willing to run their data. I thought the record showed SSA was willing, and then CMS said sure, and then changed their mind and said no, we won't.
No, Your Honor. There's a letter from the SSA in the record that shows that the SSA was not willing to do the sampling and actually said, we don't understand the confusion. We never said we were willing to do it, and that's so. It's in there is a letter in the JA, and I apologize, I don't have the exact site for it, but the SSA did say that they were unwilling to do it, and that's not information CMS has itself.
And just one other thing, I know this is many steps down the road, just to try to understand what's happening here. Imagine they go back and do what you want them to do, and the board goes, wow, there's a problem here. Mm-hmm. At this point, can these numbers even be rerun by CMS? Or could this, if they said, oh, it turns out we can't figure out what human error was, an inputting error, did the computer have a glitch? We just can't figure it out. The power went out, turns out the power went out the day this ran, so maybe that's the problem. Could it even be rerun? I'm just trying to figure out how this could even be fixed at this point.
Your Honor, I think, there are two answers to your question. If the board had found they came forward with this kind of evidence, then if the board actually found that the hospital met the burden of production, then CMS would have an opportunity to come forward with, some kind of evidence. And so we'd have to go through that step too. And if,
I'm assuming so. The board finally says something. I know it's a lot of assumptions. Right. I'm just trying to figure out what remedially how this, because by that point we are probably close to 20 years after the fact.
Well, but I think
is the data still safe somewhere that it could be run again, or how would this even work?
I mean, and I'm sorry, I can't answer in the abstract because I don't know exactly what cost here, it would be. There are certain things that I think in some of the hypotheticals where you're just looking at MedPAR data and, CMS sent Pomona the MedPAR data for a much smaller hospital in Iowa or something, and that could be fixed. That could CMS could look at its own information and say, wait, our information doesn't match up with that. So if it's something more complicated, that and using the SSA data, I mean, I think that is another reason that in the rulemaking, some providers said, we want you to go beyond 15 months. And the agency said, there's got to be, we're doing longer period than we used to before, base date, but there's got to be some finality here. And the standard for best available evidence in the Methodist Hospital case says this when it says, we're not going to have the agency retroactively apply this new wage index, is using the best available data to you at the time. So, Your Honor, there are no further questions.
Thank you, Rich. We'll give you 2 minutes for rebuttal.
Oh, thank you, Your Honor.
May it please the court. I'm Sven Collins, counsel for Pomona Valley Hospital. And I'd like to just give a couple words about Pomona, just so you understand who the hospital treats. It's a hospital in California. It serves several communities with a high percentage of low-income residents. And of course, those low-income residents cost more to treat and providing their care. Because of that care, it's very important that the hospital receives the appropriate DSH monies that Congress directed. With us today is Candace Leitron, who is handles Pomona's Medicare reimbursement, and she was a witness at the board hearing. And I think I probably don't need to say this, but Pomona did everything it could and then some to demonstrate that the secretary's fractions were incorrect.
No, you didn't. You didn't back out nursing home data. You came in with, as I said, general statistics, but you could have actually, instead of showing that it was statistically or arguing that it was statistically insignificant, you could have done it. And you could have dealt with the eligibility and actually cranked the numbers. I know you have witnesses that say it wouldn't have been worth the candle, it wasn't statistically significant, but you could have actually given them more precise data. And the standard is, did you present allegations supported by all the information available to you? That's what it takes to shift the burden, right? You didn't do that. You could have done more. And then they say you could have given us the definitions of the codes 10, 20, and 60. So as to those three specific things, can you tell me why you couldn't actually have backed out the nursing home folks? You couldn't actually have backed out adjusted based on eligibility dates, and you couldn't give the definitions of 10, 20, and 60.
Yes, Your Honor. And the board's statements in the order are not supported by the record that we could have done those things. There's no testimony that we could have. And in fact,
is there testimony that you couldn't?
What?
Is there testimony that you could not have done it?
Yes, there is testimony that presented that, well, I don't think there is. They were asked the question, can you provide that?
Okay, so
they weren't asked the question. So there's not, you're right.
No, but you have the application with the information you have available to you, and you're not able to say that you couldn't, with the information you have, that you couldn't have done it. It's just that you didn't do it. And I understand your rationale being, look, This isn't worth the trouble, but you could have done it as far as this record shows.
So as far as the record shows, the board did not question us if we could have provided more precision. And so therefore the record does not have anything in there. The reality is Pomona,
you're not here to say that you couldn't have done it. You're not able to say that you couldn't have done it.
I can't say that.
Right. You cannot or cannot?
I can say we couldn't. I can tell you.
I thought you just said the record doesn't show that you couldn't have. Sorry, on this record, can you say that you could not have done it?
On this record, I can't testify, so no.
Okay.
But anyhow.
I'm not asking you to testify. I'm asking you to point something in the record
Yes,
to be clear.
yes, I understand, Your Honor. The data that was provided, the unrebutted, unrefuted evidence was that it was statistically insignificant. And the board, the additional items the board called for, the secretary didn't put in any evidence suggesting that it was available to us, that we could. The Medicaid, that data is not tracked by Medicare, nursing home days. Furthermore, the days, what is in the record, and my friend on the other side pointed this out, the email from the state Medicaid agency, the sentence she read, she didn't read the entire sentence. It says, and this is about the nursing home patients, they go into long-term care and they'd stay in the aid codes 10, 20, and 60 for 3 months, and then revert to codes 1E, 2E, or 6E. What's the importance of that? After 3 months is when the SSI payments stop. So at that same moment, when the federal payments are stopping, the Medi-Cal system is coding the patients differently. They're no longer 10, 20, or 60. So therefore, Pomona's record shouldn't have even picked up any of those nursing home residents who are beyond their SSI entitlement. Now, I'd like to just talk about the crosswalk.
Yeah, let's do that, because I'm sort of with you on the de minimis points, but the failure to provide a crosswalk, what they call a crosswalk, seems like a much bigger problem. And crosswalk's kind of a jargony sounding term, but what we're talking about is you're trying to use state codes as a proxy for federal data that you don't have access to under these federal codes. And you need to show convergence. And I mean, that seems like the first step in doing that is figuring out what the federal code covers and what the state code covers. And then you look at the Venn diagram and figure out, is there a lot of overlap or just a little?
Yes, and I'm glad that opposing counsel brought up the crosswalk, because Pomona provided a flow diagram that the board explicitly asked Pomona to provide, and that's at the Joint Appendix 85 to 88. And it's a real head scratcher why the board said Pomona should have produced more. Pomona would have loved to produce a true crosswalk. But because Pomona lacked access to the SSI data, there was nothing Pomona could do to create a crosswalk or otherwise that would get to the level of precision the board demanded. If you look at the pages I referred you to, what the state agency provided were indicator codes that the 3 state Medi-Cal codes are created from. These are the federal codes that turn into the 3 codes that indicate, that tell you someone's an SSI category individual. And if you had an actual diagram that explained what those indicator codes were, and the state representative told Pomona, we can't tell you, you need to talk to SSA. Well, Pomona spoke to SSA, and that's in Ms. Letran's declaration, post-hearing declaration, that they couldn't provide the crosswalk. So they provided what they were able to. And if you think about it, even if you knew what each of those indicator codes actually said, other than generally translating it to one of the 3 aid codes, that wouldn't tell you how many of Pomona's matches were actually something other than active SSI entitlement. That would not tell you that would not get you to the level of precision the board was demanding.
So sorry, the level of detail in the codes is not publicly available?
It's not in the record that it's publicly available. The unrebutted record is that Pomona was unable to provide more than the flow chart, and provided the flow chart. But do you know who could have provided this information? to the extent it's relevant, the other side. Why didn't they introduce a code, a paint by numbers crosswalk if it was so important to the case? Now, they produced nothing. Pomona diligently provided specifically what the board asked for, and it couldn't take it any farther. And the problem really wasn't the form of the information, but it was Pomona's lack of access to the underlying SSI data.
Can I ask on J85, when you talk about values, so it says the first indented bullet point, values 2, 3, 6, 7, blah, 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 are set as blind aid code 20. What are these values? Are these federal or is this a California thing?
Are you looking at the line that
I'm on
says,
page 85.
Yes.
Mhm. Under state processes data, you've got bullet points and then you've got indented bullet points. First use STX filed multi-category, field 1520, it's all gobbledygook to me, but under that it says values 2, 3, it says what is aid code, what shows up is code 20, and what shows up is code 60 and code 10, and it's all preceded by a bunch of numbers or letters that maybe they're defined somewhere else but aren't defined here. Who knows what value 2, 3, 6, 7, F, G, O, P, S, T, Y, and Z are?
Those are numbers and codes generated by the SSA.
Okay,
itself.
those are
And
not
that-
California things. Okay.
Not California, Your Honor, correct.
Okay.
And those are the indicator values are what the California representative employee told Pomona would be available from the federal government, and the Pomona didn't have access.
Okay.
But also, I just go back to the point that even if you knew exactly what those indicator values said, and there was some potential other category of non-SSI payment, that still wouldn't tell you how many of Pomona's days in the match that Pomona believes from the state data, from the state aid codes, were incorrect. It wouldn't get you to the precision the board demanded.
Well, can I just clarify one other thing too? When you say these values are set as blind aid code 20, or set as disabled aid code 60, set as aged aid code 10, is this exclusive or is this just inclusive? When they say these values, are these the only values that get set as blind aid code 20, aid code 60, aid code 10, or are they saying these things and there could be others? Is it exclusive or inclusive?
Your Honor, the record is that it's exclusive.
These are the only things that California can, look at these numbers and letters from SSI, and those are the only things that California counts as aid code 20.
That's correct, Your Honor.
So then it's really just a question of timing, but we know that these same codes are used to cover supplemental payments too, right?
Correct. Because the supplemental payment is an automatic payment that someone receives if they're slightly, if they're SSI entitled, they receive the state supplemental payment also. And as we've all gone over, as the court's gone over, some of those days are actually overcounts because they're individuals who have a higher income. They wouldn't be eligible. They wouldn't receive an SSI payment, just a state payment. But all of that, the unrebutted record there is that that was backed out completely.
So let me ask you, so if we don't have a perfect comparison of the codes side by side, right, as if you were comparing legal elements of statute A to statute B, right, that would inclusively show what's overlapping and what's not. We don't have that. What we have instead is a lot of expert testimony showing that there were at least 3 non-overlap issues. And let's just take Judge Walker's formulation that 2 of them were de minimis and 1 was corrected for. Where in your case, in your expert testimony, do you get the proposition that there were no other problems or non-overlap than those 3? Where do you get that?
I think that is where that's the adversary process. We presented, and the board asked about 3 specific.
It's just the expert testimony.
Yes, the expert testimony, And in the expert testimony, the experts testified, and this is primarily Mr. Rosenstein testified that there were these two potential situations, and they were accounted for de minimis, immaterial for purposes of the analysis. They couldn't account for the entire difference, and there were no others identified by the secretary.
Do you have a site? You have a site for me where he says, and there's nothing else?
That could explain this difference.
There is testimony, and I'd have to find it, where he says, I can't think of any other reason. I can't think of any reason why there should have been this enormous difference between what the state data is showing us and the government's matching. So that I think is the closest you get.
It's the expert judgment of someone who was in a position to understand all these figures that sort of look like mumbo jumbo to me. But
right.
He says there's no other explanation, and they say, the two experts say that, and that's what cinches up the case for you.
Okay. And Your Honors, I think what the Secretary's arguing here is that its argument boils down to, we explain what we're going to do in a 2010 rule, so there's nothing more to be done. And as clearly mistakes can be made, clearly we've demonstrated mistakes were made in the record, unrebutted. And at that point, I wanted to get to the import of precedent. We believe under the Atlantic College decision that the burden, we did enough to shift the burden to the government, put up something to rebut our evidence. And under Atlantic College, it's not necessarily that the government exclusively has access to the information, has better access. And here we believe the most meaningful information, the only thing that could get to the bottom of the cause and the scope of the match problem would be the SSI data that only the government has access to.
So short of having that data, I think you have a slippery slope problem and the government has flip side of the slippery slope. There's always going to be some data set that churns out a different result when the same model is applied to one data set versus another data set. The government has picked its data set, and there's no challenge to saying the government's data set is a perfectly fine data set to choose. Your theory, I think, is that human error or computer glitch, something about the application of the 2010 methodology to a perfectly fine choice of data set led to an error. And the government has a problem. That they can't propose to us a theory that would never let a hospital prove that human error or computer glitch led to, let's say, a $20 million difference in what the hospital was entitled. And we asked the government about that, and she addressed that question. My question to you is, there's always going to be a better data set for you, not necessarily a more accurate data set, but if you were to go out, you picked Medi-Cal, but if you were to shop 10 data sets, 9 of them lead to a lower number than the government pays you. 1 of them leads to a higher number than the government pays you. You could just pick that one data set, go to the board and say, oh, you miscalculated. And let's say you win that case. And then the next time the government, produces a number, you or another hospital could pick not that data set that worked for you last time, but the data set, the 1 out of 10 that works for you the next time. What's to stop that from happening if we rule for you in this case?
What's to stop it from happening is Pomona wasn't out shopping data sets. It was using their 2 basic sources of data that could tell you something about who has SSI entitlement. 1 is the federal data. 2 is the state Medi-Cal data, because those
are the only 2 data sets that exist that tells you who is, usually somewhat, people who are low income, people who have visual impairment, and people who have disabilities. Are those the 3 things?
I'm not aware of another data set that would provide that information. Obviously, the federal government's data set has a level of detail that can tell you, yes, someone's receiving payment that month or not. The state data indicates that, and in most instances, it should be accurate, and we've accounted for the issues. But this isn't like civil litigation where you can go and hire any number of experts to crunch data and come up with different models and analyze things. This is Pomona went out.
You didn't do the form shopping equivalent of data set shopping.
Correct.
And you couldn't have done it.
No.
And no other hospital could other hospitals couldn't do it either.
I don't believe so, Your Honor. And the Pomona didn't set out to get more money. Pomona started this process because its fractions shrunk and it wanted to know what is going on. And it had a source of data and an analysis that showed that there appears to be something wrong. As both experts said,
you probably would not have gone to the board if you found out that you were owed less money.
That's absolutely correct. I mean, Pomona went, when I say and then some, it's been an entire laborious process trying to work with the agency through U.S. senators to get to a resolution. And Pomona was it's undisputed testimony, 100% willing to walk away if the SSA had taken the 50 sample set and said, sorry, none of those are matches. Pomona would have walked away. That's the undisputed testimony. Pomona here is trying to find out what happened. It appears that there's a massive problem in the secretary's actual execution of the 2010 rules match. I mean, the secretary's argument assumes the output is correct because the secretary's inputs and its process are unrebuttably infallible. And
you do not contend that the agency used the wrong methodology.
I'm sorry, Your Honor.
Maybe make it. The agency used the right methodology, correct? The 2010 methodology.
As described in the rule, sure. But what the secretary.
You're not challenging that.
Correct, Your Honor, absolutely correct. But the secretary has provided nothing to assure the court that the agency's actual matches for Pomona or any hospital reflect the underlying data or use the correct process. No reports, nothing. And there was no validation at all, even in the agency's own process, for the 3 years at issue here for Pomona's matches. The agencies described some validation that might occur for later years, prospectively 2011 and beyond. Nothing for these earlier years. So the secretary undertakes a very significant effort after base date to all these cost reports are on hold, and it corrects across the country all the cost reports, all the SSI fractions for all the hospitals around the country. Hands them out in 2012. And there's literally nothing that the agency produced, that the government produced, to assure the court that it did it correctly. And our data and our unrefuted evidence at the board hearing showed they did not do it correctly.
And your theory is so something, even with take their methodology is correct, something went wrong. I forget you had a line of human error, computer error, or something like that, right? Something went wrong these 3 years in applying your methodology.
Yes, Your Honor.
Right. Has that same problem, this is 2006 to 2008, did the same problem continue in 9, 10, 11 in subsequent years, or is the problem not there and this claim really is confined to something went wrong these 3 years?
In the record, Your Honor, it's focused on these 3 years. Pomona has appeals for other years.
On the same basis, using MedCal data?
It has board appeals. They have not, none of them have gone to hearing.
Is it on the same basis, though, that there's a gap between the MedCal data and what the SSI numbers showed?
I believe that the board issues are very similar.
Very similar. For how many years?
I can't recite that off the top of my head, Your Honor.
Maybe a rough estimate?
I mean, I believe it's for the next several years.
Okay. Doesn't that decrease the prospect that it was actually any kind of human error or computer glitch? Because if it was, you wouldn't expect it to be repeating for 3, 4, 5, 6 years.
Well, the problem, Your Honor, is we don't know what the problem was.
Well, in Bay State, they said, here's what the problem is. These files, like these different types of files aren't being counted. And so isn't that part of your problem here is you went and got some other data and did your best to compare them, but we can't really compare the two exactly, is your theory. We can't line them up exactly. We don't have that information. But it seems like every single year for however many years, there's a gap between the two of them. How is that not actually a challenge to the rule decision that these SSI files are the best available data?
Your Honor,
Because it can't be human error that many
we're
times.
challenging it as applied in each of the cases. And we haven't seen how, other than the results, we haven't seen how it's been applied.
But you don't have a theory as to what's wrong with their data. You're not saying there's some, so now if you've got even more than these 3 years, you've got a lot of years now of some gap between MedCal and SSI. But you haven't yet figured out a theory as to what are they not counting? What is their file not capturing? Or what are their human beings not capturing? It just seems to me that your collective argument is your files, your SSI files, are not, in fact, capturing what they should. They are not the best available data. As it turns out, at least for Pomona, they're not the best available data. Or maybe for California hospitals, they're not the best available data.
Again, I think, Your Honor, they've described the process. They've said what they're doing. We don't know what they're doing. We just
No, but
don't.
the point of views collectively over all these years making these arguments is that it's not working. You're not getting what you should be getting. That's your argument. That's your argument here is MedCal shows you are not getting all the people you should be getting. You're not disputing that they use the files as they said they would in their rule. You're not disputing that, correct?
We're not disputing that they describe the rule, describe what they're going to do. No, we're not.
Well,
disputing
not
that.
just and you're not disputing that they did do that, other than that there must have been, human error or computer glitch, but that they actually took those steps and then something went haywire in the process itself. But that is actually the process that they applied to you.
Yes, I mean, it's supposedly the process that was applied. We're not challenging the process. In the other board appeal.
And you're not saying they didn't apply that process here, like intentionally, that just some accident went on, something went wrong.
We're in a complete information gap as to why it didn't work. We don't know. The Secretary's SSI data can demonstrate that. I can't make hypothetical arguments. I mean, I can make hypothetical arguments why it could have happened, but I don't think that's going to advance. That doesn't advance our case. We've demonstrated there was an error. The SSI data would demonstrate the cause and the scope. These other cases that have not been, that have not even gone to hearing, I mean, if those cases could conceivably challenge the methodology, those are other cases.
Let me give an analogy, and you tell me if it's related to Judge Millett's question. Imagine a case from my memory where 10 years ago, Yale's student clinic, law school clinic, had a policy that the cover page would always say the court where they were litigating, the United States Court of Appeals for the Ninth Circuit. But the first time they did it, it actually said the untied states of America for the Ninth Circuit, untied states Court of Appeals. And every time they filed a document in that case, it said the same thing. Their policy wasn't to say untied states. It was a glitch. It was a human error. And because they started with the wrong template, they repeated the error over and over. It could have gone on for years. Is that at all relevant to the kind of glitch that might explain how this error that you're alleging to go on for years and years and years, even if the methodology is sound?
Yes, Your Honor. I mean, if they set up a template and it's repeated year after year and the template's incorrect, absolutely, that could perpetuate an error that wasn't intended, but that is occurring in that process. And if the Secretary has, the Bay State case, Secretary, of course, said their process was wonderful and should be sustained, and Bay State demonstrated the opposite. I mean, if it turns out that their process, something is broken, mean, that, it should be fixed. This is a challenge. This is an as-applied challenge to the agency's process.
Yeah, I think the difference is someone could have pretty quickly figured out what the problem was with the difference there. And it's the difference between you and Bay State, again, is over time, you keep finding these gaps and you've got this data. Shouldn't you have been able to sort of figure out what the problem is and present that to the secretary?
Well,
which of my patients aren't getting counted? Which are showing up here and aren't showing up there?
And it's going to be different every year. I mean, I can't go.
Well, if it's different every year, then it would have. If it's different every year, then it can't be sort of a common.
Sorry, Your Honor.
It's not a common problem then if it's different every year.
Sorry, Your Honor. What I mean is it's going to be different patients every year. So, and anyway, I'd just like to spend 2 minutes on relief in our cross appeal with respect to the adverse inference. I know I'm well past my time. Since the secretary here offered no evidence in rebuttal, the secretary shouldn't get a second bite at the apple. And the court instead should apply an adverse inference by vacating the SSI calculation. Going beyond what the district court did, which was to remand to the secretary.
Yeah, any case where we have done that in an APA remand that you can cite to me? Do you have any case in an APA remand where we applied an adverse inference? Or any court has applied an adverse inference?
No, we don't have that, Your Honor. But the same principle, the government had its opportunity to present its defense. It failed to present that information, and it should not get a redo of the actual hearing.
Sorry, when you say adverse inference, what exactly do you mean? That we order the agency to go with your California numbers?
No, simply that you would vacate. And we 100% acknowledge that.
Because your affirmative case is we don't know what the right number is. We just know that the government's number is wrong. So, I mean, what could we do in those circumstances other than vacate and remand for further proceedings for the government to figure out what the right number is?
And this is the additional relief we're asking for, but we believe it's consistent with this court's powers, which is to vacate the SSI calculation, not simply to vacate the board's decision, vacate Pomona's SSI calculations because we've demonstrated they are incorrect. Then it gets remanded to the secretary to recalculate. The secretary is able to use
vacate the action of the Medicare assistance contractor.
Vacate the action of secretary determine the SSI calculations. And so vacate the secretary's SSI calculations for Pomona and remand to the secretary to recalculate the fractions in accordance with the court's decision.
Recalculate how? Just run the data a second time? Rerun the data?
They would recalculate and demonstrate, provide their data demonstrating their results.
Sorry, I'm trying to make sure I'm understanding what you're saying. You want them to rerun, so we'll make sure there's not a computer glitch. We want you to just take those files again and rerun them through your computer again. Or do you want them to run them with the Medi-Cal numbers?
Well, I'd love them to take our numbers and rerun those numbers would be one way to determine if the additional days were accurate or not from the Medi-Cal numbers. That would be the simplest way for the secretary to recalculate on remand, and the secretary could obviously at that point demonstrate that some of our numbers were mismatches and inaccurate. But the secretary would then part of our requested relief would be to have the secretary provide its data, show its math, so to speak, and not just show the results, which is the only thing.
This data is all the stuff that's protected by privacy laws and HIPAA. That's what they would have to show you?
Well, it's a little bit of it's a straw man to say that the government would have to produce all of its SSA data. It would only have to provide the records related to the matches from Pomona.
Okay, but as to Pomona, is to get all this protected information.
And yes, Your Honor, Pomona has already the most sensitive protected information for all of these same patients, of course, because under HIPAA they're permitted to use it for purposes of payment. But the only thing that Pomona doesn't have with respect to these patients, they already know that they're eligible for SSI under the 3 aid codes. They already know that. The only thing they don't know is if they're receiving active payment or not. So really, the privacy issue is a bit exaggerated on the government's part. And the government, of course, has the ability to provide limited data sets. It did a limited data set. It could modify that for purposes of resolving this case with Pomona.
Our jurisdiction is limited to judicial review of any final decision of the board, meaning the PRRB. So where do we get the authority to look beyond that and set aside this SSI calculation, which is a different agency action by a different administrative act?
Ultimately, the appeal concerns the determination of Pomona's SSI calculations. That's the root of it. And Your Honor is correct that you're reviewing the board's decision rejecting our appeal. We believe that it would not be inconsistent with this court's authority to direct the calculations because in the hearing process, the Secretary offered no evidence to rebut Pomona's case that the calculations themselves may be vacated.
Great, thank you very much. We'll give the government 2 minutes. And I think you wanted a cross-appeal rebuttal as well?
Excuse me?
You asked for a cross-appeal rebuttal as well? The government's going to get rebuttal now, and I understand you wanted a rebuttal
just a minute, if we may.
Solely on your cross-appeal
Yes.
issue.
Yes, Your Honor.
Thank you, Your Honor. On the cross appeal, we'll just rely on the brief where we cite the relevant arguments for it.
Could you just put the mic down?
Oh, I'm sorry.
Evan?
Is that better, Your Honor?
Yeah.
Can you hear me now? And on our appeal, I did going to JA 85 and 86, which Mr. Collins referred to. That is nothing like a crosswalk. It's just the process by which the state gets the data and puts it in the different categories. And that's not what the board was asking for. And it's not
No, but why doesn't it provide what you asked for, which is a definition of what gets covered under these codes? This is what 10, 20, and 60 cover. And that is the numbers and letters listed there from SSI, which would allow very easily to say, well, you shouldn't be including 7, or you shouldn't be including S or Y, right? It gives you what you said before was where's, we don't even know what these definitions mean or how they map on to SSI. It seems to me that it answers that question. The SSI codes, I meant, sorry.
No, I don't. I mean, I don't think it does because they don't say what those codes are.
They say they're your codes.
They said these are different from, I mean, I don't know if the S code is an S code that was discussed in the rulemaking, for example, of suspended.
Why does it matter if they say these are numbers that come from SSI, and that's what we put into aid code 10, which apparently, 10, which corresponds with those who are blind. And these are your numbers.
But they don't explain whether that is limited for, and it clearly isn't limited to just people receiving payments because they include the SSP and they include the nursing home and they include the different, and regardless of whether those are minimal discrepancies, this isn't an actual, explanation of what the limits of those codes are. And, probably more important, Judge Walker, you asked a key question here, which what is the limit of what the hospital, if the court allowed the hospital to go forward with this kind of data, other hospitals in other states presumably have state data. And if the board is best positioned to judge this data and examine it. It heard the witnesses. Mr. Rosenstein, they referred to his declaration. He was certified as an expert on the California program, but not on how it corresponds to Social Security. And the board had a lot of questions. And again, the board initially pointed out this very, very large mistake on the state supplemental payments. If there is a discrepancy, it could be a California computer problem. It could be a California human error.
So this could happen in all 50 states. I agree with you on that.
And that would become
that's either a feature or a glitch. If you're actually doing it wrong because of human error or computer problems in all 50 states, you should want these challenges to be raised in all 50 states because I'm sure you want to be paying whatever the accurate amount is. It would be a glitch if there's the kind of data set shopping that I hypothesized. And your opposing counsel said that's just not a concern at all. Do you agree with him or disagree with him when he says there's really no reason to worry about data set shopping?
I don't know about data set shopping, Your Honor, but I do think there is a worry about relying on hospitals coming forward to try to invalidate fractions based on unreliable data and not the best available data. And what we're saying, yes, we certainly, the agency, and we hope that the 2010 rulemaking reflects this, that the agency is trying to do it as accurately as possible with the best available data. If a hospital did meet the high burden and could, somehow show that this really did occur, our point is they didn't here. And if it weren't, and the board.
But are you saying they can't rely on state data to do that? I don't know what else they would use.
No, we're not saying that they can't. We're saying that here they didn't show that there was sufficient congruence between the state data and the SSA data.
I know when you say, well, maybe there's something wrong with California computers. I can't disprove a lot of negatives. I don't, right?
No, but that's just another example of if you have of one of the problems and why the burden of proof is on the hospital here, that the secretary has set up this system. And if there were computer glitches or human error, presumably quite a few of them would be caught by the MedPAR data, which is what, Congress passed Section 951. Since the 2005 rulemaking, Congress hasn't indicated that the secretary needs to turn over any additional information. They have all the information legally and required under the statute and the regulations, and that information does give them a way to look to see if there is, a kind of glitch in the federal system, because they can look at the number of patient days and they can look at the number of entitled days, and if that information, it doesn't match with the MedPAR data. But the problem here, they're using a whole separate set of data. And they haven't established to the extent that we're not saying it's impossible. We're just saying they didn't do it here. And the board went through step by step why they didn't do it, held a full hearing, allowed them to submit, as much evidence as they could. And they didn't do several of the additional evidentiary things that the board asked for. And for that reason, and the board's decision should get some deference from this court under APA deferential review. And so we would ask that you reverse the district court and hold that the board's decision was supported by substantial evidence.
Thank you.
Thank you.
Thank you. Collins, we'll give you 1 minute.
The court asked if there was any precedent where the court set aside the agency's fractions in this scenario, and that is actually the Bay State order from from the district court with the secretary's agreement, which the secretary agreed with, was that the fractions should be vacated and remanded to the secretary to recalculate them.
Yeah, but there they found a legal error in what they were covering and not covering. And so they just said, you can't be excluding these things. But you're not alleging legal error, you're alleging human error or computer error here, right?
Correct. You
don't know what the error is.
Absolutely, Your Honor. But abstractly, it's the same thing, that the fractions there were vacated, whether it was because it was actually a legal process error. They didn't count days they should have.
Well, it's not the same thing because it's legal error. Then courts can tell the secretary or the board to ensure that its decision comports with what the law requires. But there isn't a legal challenge here for us to tell them that they need to comport with on remand.
But the legal challenge is we've demonstrated that their calculations are wrong, and we proved it. The government didn't rebut. Thank you, Your Honors.
Thank you. The case is submitted.
Stand, please. This honorable court is now adjourned until Wednesday, September 7th at 9:30 a.m.